A DS order was with the mother, Miss Severa, but without prejudice for court determination. Looks like on February 2nd, Dad was to take Ian per text message. Sounds like Ian has some medical issues. Is this just about Ian versus Ian and Jonathan, ma'am?
Both boys.
All right,
Jonathan Jr.
All right, so what is your request then? You want custody?
Yes, full custody, because I haven't seen my son. Today marks 3 weeks.
And how was it that he got, I mean, you say he sends you a message, a text message, that if you don't do it, he's gonna call CPS. Why didn't you call his bluff?
He called me saying that to come home, that it was very important, and that he showed me a text message saying that he has to take Ian. If not, if I start fussing, he was to call CPS and the cops on me.
What, have you done something? No, the cops? So why didn't you call his bluff and just say, so call him?
I just didn't know what to do, because it's my first time this happening to me. So I was so confused.
All right. I'll hear from Mr. Nickens. Is it you're keeping your child?
Because DPS told me if I don't, they will take him. The day that it happened, I was at work and I got a call from the CPS worker, because they've been doing an investigation on her. I don't know how long, but I think 2 weeks prior to this, CPS had came out and did some questions and, took my information, and that's how they got my contact number. But on this day, they had called me while I was at work midday and told me that it's an emergency, that it's urgent that I get my son, or CPS will take him. That's the text that she's talking about. I'd never threatened her or anything. I did ask her to come home because I didn't want to send her a text saying that CPS told me to get the boy.
What is CPS saying they're investigating?
Well, because of she been canceling appointments. They got her for lack of nutrition. She got a daycare service that come and help with the disabled boys. They've made complaints. CPS got they filing what they said they're doing an investigation of. It's a whole bunch of things that they putting together. And she knows about this because she had the conversation with the CPS worker.
Ma'am, you must have had a conversation with CPS. They're not doing an investigation, not having contacted you.
Yeah, because I didn't get no list of complaints. I didn't get no court order. I didn't get anything. And then if it was CPS, why would they text them saying to call the cops and CPS?
Well, all I'm saying, you've been talking to CPS, right?
Yeah, but it wasn't nothing about no missed appointments or anything, because I showed them that I was there. Yeah, I may be 10 minutes late.
What did they come talk to you about? CPS doesn't just walk in and say, hi, how you doing?
Well, they talked to me because they received a call on February 9th at 10 p.m. saying that my son, Jonathan Jr., was never on oxygen. And I said, that's a fib, because he's 24-hour on oxygen. They didn't tell me anything about Ian.
You said
at 10 p.m. and they didn't show up to my house on, not February 9th, January 9th. At 10 p.m. they received a call and they didn't show up to my house till January 10th.
Okay, so you have both kids at your house?
No,
I only have Jonathan.
This is what happened when I took them.
But Ian needs to be home.
Hold on a minute. I'm asking him, all right?
When I took him, our son Junior was still in the hospital. So
your son Junior, is that Jonathan?
Yes, that's okay. Jonathan. Sorry.
It's all right.
So he was in the hospital. I was going to take both of the boys, but CPS and Family First is trying to work with her, trying to get to see if she's fit to care for the boys. So since they wanted to work with trying to see if she can get the boys, I was like, well, when Junior get discharged, then he can stay with her. So I was actually trying to help her out, prove that, she's able to get the boys. But so that's what happened with Junior.
Right. So you're still dealing with CPS?
Yeah, I haven't.
Yeah, but all I know, I'm having home care services start first thing Monday. And what I was trying to let him know that, he needs to come home for it. But I'm getting no response or anything.
What do you mean you're having home care services? They're going to
nurse, home care nursing, yes.
what's Ian got that need?
The both boys has Emmanuel syndrome. They have cleft palate, was born with cleft palate, where they had needed a trach and a G2, you know, to breathe, and yeah.
And so how often is this nurse going to be there?
At least Monday through Friday from 8 a.m. to 6 p.m.
Every day?
Yep, for both boys.
Can you confirm that?
That's not, they do certain days a week. They don't do Monday through Friday. Ever since they've been coming to our house for the last year, since I know of, it's been 3-4 days weeks max. The problem why another reason why CPS is getting involved is because you need 2 people there, and she doesn't have 2 people there all the time. And sometimes she leave them with her 2 oldest kids, which is I think is 9 and 11. I don't know their ages, but they're not capable of taking care of him like that, and she leave them like that on numerous occasions. So like,
so you have 2 people present at all times there?
yes, and one of them is
I do. Here's, I'm not sure if you can read this. I'm not sure if you can read it that good. This for the home care services that they're going to start. His name is Michael from 8 a.m. Monday through Friday. I'm not sure if you can read it
Yeah,
that
it says
good.
8 a.m. to 6 p.m. Monday through Friday. I don't know who Michael is.
Yeah, he's the home care services.
All right.
But my concern, Your Honor, is the safety of my children.
Well, my concern is the safety of your children. All right. And here's the problem. CPS, if they are putting services in there to help her with it, then it doesn't do, it would be good to have your son there during some of the time, at least, if they've got somebody there to help.
Right, but she hasn't been compliant with them, Your Honor. They've been trying to call her. Ever since I had my son, Ian, she's been canceling his appointments. He needs supplies for his condition. She's been making that difficult. CPS has been stepping in to help me make sure that I get the things that I need because she's been making things difficult, Your Honor. I fear for the safety of my children.
All right. Jonathan is being cared for by her.
Yes, he's with her right now.
Okay. Okay. And both of them have basically the same condition.
Yes.
Okay. So the CPS can help out there. All right. Well, ultimately, I mean, there's only initial custody was granted to mother through the I think it's a DS case, and that is without prejudice to court determination of who should have custody. So I'm left with, I have to have an evidentiary hearing. These are what the court calls for. I have to have an evidentiary hearing to determine proper custody at this point. I guess what I'd like to do from here is I would like to have, I'm going to refer it to the friend of the court.
Okay.
Because the friend of the court can talk to CPS, can talk to this, can talk to you, can look at your documents, and all that kind of stuff, man. I'm going to refer to the friend of the court for custody, parenting time, child support, all those things. Okay. I'm not, you guys got enough going on that I'm not going to charge you for it. Normally it's 150 from each parent. I'm not going to charge you. I'll waive that fee. Okay. And then, so right now Jonathan's with her, Ian's with, I mean, isn't there a way that, yeah, I mean, I assume you want to see Jonathan some and she wants to see Ian some, okay?
Like she told another fabrication. She have seen him. We had a doctor's appointment together for Ian and Junior yesterday. And every time because I live in Baldwin, every time I come in town for Ian's appointments, she sees him. So just want to throw that out there.
That was my first time seeing him and finally holding him because he don't contact. He doesn't respond.
How old is Ian?
Ian's 2 years old. And like I said, if he stay in Baldwin, how can he keep a complex baby boy who's going to be in the back suctioning him? And not only that, on the previous motion that he said that he's going to be evicted, you know, how he's going to do it with a complex child.
That's Ian right there.
Okay. Okay. Go ahead. Don't. Yeah. Okay.
Yeah. So on the previous motion, he said that he was going to be, you know, he wanted to lower down the child support because he was going to be evicted and he was 2 months behind. So if that's the case and you're in Baldwin with a complex baby boy, who's there going to help you suction in, and you're going to be living, you know, where my son's going to be at? If that's the case, then.
Do you know the name of the protective services worker?
Yes, Miss Leslie Bryant. Not sure if you can see it.
Leslie Bryant, just a minute here. As of right now, I'll leave, Jonathan with you, Ian with, but I want somehow her to be able to see or to be with Ian at sometime,
That's
okay?
fine, yeah.
You're in town now. I don't know if she can, are you working, ma'am?
No, I can't work because I'm taking care of both complex baby boys.
Okay.
I'm their caretaker, nurse, pulmonology, respiratory. I'm all that for them.
Yeah, and I understand. I mean, I'm concerned if CPS is looking, if they're contacting him, and I'm gonna contact CPS when I'm done here and see if I can get anything. We'll refer it to the friend of the court. In the meantime, I guess as a temporary basis, is there any reason why she can't have him during a weekend or something like this?
And that's what I told him. But CPS told me, you have to contact dad. You have to contact him. And I said, how can I contact him? He's not responding.
Well, sir, you got to respond. Okay. I mean,
That's not true, sir.
well, I know you're going to deny it. She's going to say it. I don't know what's true right now. Okay. You got to understand, you're conflicting here.
That's
Okay.
fine, that's fine.
And so all I'm saying is you have to make sure you respond. Okay. If you're responding, great. If
Yeah.
not,
Okay.
and since you're down here right now, can she see, Ian for whatever, the day or something? Where are you going back up?
Yes, no, he has an appointment at 10:30, then I can drop him off to her and she can see him. Okay, I'll drop him off to you for 3 hours, okay? And you can see him, then I'll pick him up. Is that fine?
What about the day? And then you can pick him up
We can talk about that
later.
after today. Meet me halfway.
And I try to let him know too that I know he's a working guy. I know he likes to work, that he can bring Ian to me while he working, and then he can pick him back up, after
work
his job.
here?
I work here. I'm not working right now. I took ever since I had Ian, I've been taking time. I've been taking leave to take care of him.
Well, it is. I mean, do you work in Grand Rapids?
Yes, I
then?
work in Grand Rapids.
It is since during the week you could work. You work during the day?
Yes.
You could work because there's supposed to be a nurse there during the day. Okay. And you can drop off before work and pick up after work.
Well, I'm trying to figure out this situation right now. Before I go back to work, I need to just know what's going on before I go back to work. Work is fine. I'm not worried about work. If I have to go to work, I'm just trying to figure out what's going to happen with my kids before I.
Here's my biggest problem. I don't know what CPS is doing. Okay. I don't know what they're requiring, what they're doing with you. If they're saying, no, we've got it taken care of. Ian can go back there. Ian can go back there and this kind of stuff. I just don't know.
Right. Me neither.
All right. And so, I'm going to see what that says.
Okay.
In the meantime, I would suggest that it's a good solution is to, go to work, drop the child off, pick the child up afterwards. You'd know then, because there's supposed to be a nurse there all the time. Okay. From 8 to 6. And that would be another person. You pick them up, take them home.
I always have someone with me, and she don't have a nurse with her right now with my sons. So I don't get that.
Isn't that supposed to start Monday?
Yes, sir.
But it's been weeks since she had a nurse. And I always have somebody with me with my son. But that's the reason why CPS is one of many reasons why CPS is involved. Because you always need 2 people there, not necessarily a nurse.
Okay, well, today you're gonna drop them off for 3-4 hours, okay?
Yeah.
And work with us some.
Okay.
After today, I'm gonna see if I can contact Miss Bryant. I don't know whether or not I can or not, okay? And if I can, I'm gonna talk to her and get some idea of what I think is appropriate. And my clerk will get in touch with both of you.
Okay.
All right.
Sounds good.
If
Okay.
I can't get in touch, I can't get in touch. Okay. And
She can get a hold of her.
she's not gonna, I'm not just gonna call you to say we haven't been able to talk to her. Okay. Well, let's see what happens. Work together some. We're gonna have to work through this friend of the court and CPS.
Okay.
What I'm trying not to do is if CPS actually is saying, if you drop the child off, there's a good chance we're gonna file a petition. Okay. And if they file a petition, then it comes in and the court then makes, they can start making award to the court and all this kind of stuff. I'm trying to get CPS so they don't bring you to court. All right. Cause once you get here, it's hard to get out. All right. I'm just telling you. Now that wouldn't necessarily mean that you would even be a respondent. I don't know what your situation is, but it would, and it's not in your best interest to have a petition filed for abuse and neglect in court here. Okay. I'm just I've done this forever, okay? For 40 years, I've been involved with this stuff. And once you get in court, it gets hard to get out. And I don't want that to happen. All right.
And that's how I feel from CPS being involved now. Like, it's so hard because this is my first time.
Well, we gotta work with them. They will help you. They will work with you. They need to work with you, sir, at the same time, making sure everything is fine. So I'm going to try and call her. We're just going to leave stuff as it is right now. We're going to have eventually a custody hearing on this. You're going to be contacted by the friend of the court. When you're contacted by the friend of the court, you have to get back to them. They have to be able to, they're going to ask you about things. They're going to ask you to bring in documentation or whatnot. Okay. If you don't, they only write it from the side of the person who did do it. Right. And it isn't helpful. We'll get to the bottom of it. This could take a little bit of time. I may end up calling you back in a couple weeks or something like that to see what's going on. All right. Let me just give it a chance because I don't know. I don't have anybody from CPS here. And I don't know what they're doing. I don't know if they're going to substantiate. I don't know if they're not going to substantiate. I don't want your child to be in any way in danger. Apparently CPS did say to pick up the child, and if not, then they'd file a petition, and that again would not be good for anybody, especially you. All right. So
yes.
So this isn't much of a ruling today, other than we're going to leave it as is right now. Sir, you got to have her see him some. Okay. I'm not going to set specific times because if you're working, drop him off. All right. And pick him up. And if you notice there's anything bad, okay, then call CPS. That's just something that we're going to have to deal with. Okay. Please work with her so that she is not. CPS also needs to know.
When you talk to CPS, you're going to see. They're going to tell you everything.
That's fine.
But yes, what you said, I will comply. I will make sure that she sees him.
All right.
Okay. I promise you.
All right.
So you see.
What time will you be over?
After his appointment at 10:30. I don't know when it ends, but I'll drop him off. I'll communicate with you. I'll text you, let you know when I'm on my way. I'll communicate with her.
All right. It's I got to really talk to the parties here. Okay. What?
I just want them to know that they should work, like you were saying, they need to work together.
Yes.
He's not against her. He didn't make this decision.
I understand. I don't get the impression that he.
And I just want her to understand.
I think he is kind of protecting her from CPS petition, and so just work together some. All right. They're your children. Okay, and you need to work together. All right. All right. Thank you very much. We'll see. I'm sure we'll see you in the near future, but the friend of the court will get this referral. They don't go real fast because they've got a million cases. Okay. Right. But they will be in touch with you and we'll see where things go. If I get something more from CPS that I feel like we've got to schedule some type of a hearing, I'll give you guys both notice right away. All right. Okay. All right. Good luck. Thank you all.
Thank you.
Thank you. 63DS. We have the plaintiff present. We also have Ms. Brower from the prosecutor's office. President, Ms. Brower has filed a motion to enter a judgment of support. Are there two kids? I've got Ziggy and Amila.
No, no, hold on. There's only one child on this case, Your Honor. This case is for the child Ziggy only. Around the time this case was filed, mom had another child, Amila.
Okay. So this is for one child. It says that the mom has 131 overnights with Ziggy. Is that correct?
Well, there's been some
approximate.
Changes. So there's been some changes. There was a pre-hearing conference that took place on January 23rd, 2024. The plaintiff only participated. I called the defendant twice. He did not answer. So when I ran guidelines, I ran them using mom's actual income, which is $25 an hour times 40 hours per week. I imputed the defendant to $17 an hour at 40 hours per week. Excuse me. He is last known to have worked at Pigeon and Clay, earning $20 an hour. At that time, mom indicated that the minor child, Ziggy, spends 4 to 5 overnights with the defendant per week. So I ran guidelines using 4.5 overnights per week, trying to meet in the middle. Mm-hmm. So the recommendation came out for mom to pay. And even if I use $20 an hour at 40 hours per week, which is what he last is known to have earned at Pigeon and Clay, the recommendation was still for mom to pay. The mother contacted our office on or about February 14th, indicating that the minor child no longer spends overnights with the father.
Zero
And so-
overnights?
0 overnights is what she indicated. So
Ma'am?
I
Can I,
re-
can I just add, ma'am, no overnights with dad now?
No,
What changed?
I work first shift before I was working third shift.
Oh, so you were actually taking the child there for overnights because you were working third shift?
Yeah, he went there from 8 at night till 6 in the morning when I got off, and then I
So-
picked him up.
He does, so he doesn't see the child at all now?
No,
All right, Mrs. Brower, I'm sorry.
no problem. So I reran guidelines with the minor child, spending all overnights with the mother. And the new recommendation came out to be $458 per month in base support, $16 per month in ordinary medical, for a total of $474 per month for the father to pay. So you know, that's what I'm requesting based on mother's statements. Father didn't participate in the pre-hearing conference, nor does he appear to be here today. And so that's what I'm asking, the $474 per month. And if the court agrees, we can make the effective date of February 15th, or if the court wants to use March the 1st, whatever the court believes is appropriate.
All right, well, you're not gonna like what I probably am gonna say, because you sent him notice of this with the fact that the mom had 131, and basically my understanding was there was, oh, wait a minute. Yeah. That mother was gonna be responsible to pay, but now we've changed it and he doesn't really have, he doesn't have notice of this particular order being requested, does he?
Well, just to be clear, we were never asking the mother to pay. The recommendation was for the mother to pay, correct? But then I included
I know you made
a
it.
UCSO addendum. Yes, yes. So normally our motions indicate that it says right on the motion that I'm moving for the entry of an attached proposed judgment, which, as the court knows, was for no
I'm
child
not faulting you
support.
because all the things have changed in the last couple of weeks. I'm not faulting you for what you did. I just have to make sure that
Correct,
the order that you want to enter is sent to him,
correct. Yeah,
because
I
he could show up, who knows?
yeah, I understand what you're saying, but the motion does state that I'm also asking the court to enter a judgment that is deemed appropriate.
Yes,
So yeah,
I understand, but
if the court would like me to, so just so I can try to resolve this case, I'm more than happy to send this out to him under the 7-day rule to give him time to file an objection, or if the court prefers that I just renotice it, let's say for another 2 weeks or so, whenever my schedule permits, I'm more than happy to do that as well.
I don't really prefer it, but I think it's appropriate that you send that out to him, showing what the order is you're asking to enter, okay, which is $474 to mother, okay?
Yes,
And that we reconvene. I'm not here 2 weeks from now for motions, so somewhere after that is what it is. I'm certainly not taking his side because he hasn't shown up, he hasn't contacted you, hasn't done anything, okay? I'm not trying to take his side, but for purposes of I don't know, due process, I guess I'm gonna give him that opportunity. You'd send out asking for entry of the order that now you're asking for at 474. I don't mind if at times if I modify it from 474 to 400 and stuff like that, but going
Right.
from 0 to now he's gonna have 474. And you can, when you send it out, you can use what you believe to be imputed income, okay? You can calculate that. I had no problem with imputed at $17 an hour and you were only doing 35 hours a week and stuff like that. I'm not gonna second guess that. I will go through the factors, but I've already gone through them on this one. There's no reason that it would change significantly with the next one. So I'm just asking you to renotice this with the order that goes out. We will make the order retroactive, if you will, until the 15th of February, because that's when everything you learned about the changes and stuff like that. So we'll make the order effective either whatever date you want, if you want the 15th or if you want March 1st or whatever, that'll be up to you. All right.
okay, sounds like a great
All right.
plan, Your Honor.
Ma'am, do you understand what I did?
yes. I have
I
a
did.
question.
What?
As far as the kids being there when I'm at work, you guys don't take that into consideration that I am responsible for them for everything besides when they're sleeping?
I don't know what you're saying, but child support takes everything into consideration. And as of right now, Miss Brower is asking that you be granted child support in the amount of $474. And so, I mean, I don't know what you do during the day, what you do with the kids when you are working. Who watches?
My daughter goes to daycare and then my son is in school.
And then there's no daycare expenses afterwards, after school?
No, I'm off in time to get him from school.
If you have legitimate daycare expenses, Miss Brower can look at possibly including that in the child support.
Well, I can't in this case, Your Honor, because she doesn't have daycare costs for Ziggy. She only has them
Oh, that's
for
right. I'm
Amelia.
sorry.
And I've explained that to her relentlessly.
Okay. Yes. If you had daycare costs, Miss Brower would certainly include that in. But we're only dealing with Ziggy at this time. All right. So she'll take care of it. She'll send you notice again, and we'll see you probably in about 4 weeks or something like that. All right.
Okay. Thank you.
Thank you very much.
Thank you, Your Honor.
Thank you. So far, we've got through 2 cases in a half an hour. We'll be here till 8:30 tonight. All right.
No, I'm gonna be out of here, Austin. Yes, I heard so.
Oh, we will lose our YouTube audience. Even my sister will hang out by then. She'll be asleep. Hello to all those, Cheryl, Missy, and all the others that are. Allison, who knows who.
Really quick.
Together.
Right here.
Are the 2 of you together?
Sir,
Yes?
I don't know what this is about.
All right. Dingman, we have both parties present as well as Ms. DeHaan from the prosecutor's office. She is seeking to enter a judgment of support. The support request, apparently mom is on SSD at $204 a month. And she's imputed father with some at $12.50, I think. 35 hours. He says he works some farm jobs and stuff like that. I think the total amount that is even determined is extremely minimal. And I'm struggling to find the page. Charges $28 for 2 children the mother would be paying. Is that correct, Ms. DeHaan?
Yes, Your Honor. The plaintiff in this matter is the father. This is a DC case that I motioned into. Currently, the father is receiving Medicaid and food assistance. The calculation is correct. The recommendation is that Miss Dingman provide Mr. Espinoza with that $28 sum. However, I did note that she did used to receive SSI, but it was terminated. I wasn't able to have a pre-hearing conference with the parties. I filed a motion for support on November 17th, and service was proper on November 27th. But I didn't receive any responses, so I wasn't able to hold that pre-hearing conference. However, I did make the effective date of this support order for April 1st, so that if she was able to gather some sort of documentation from a doctor saying that she is unable to work, she can provide that documentation to friend of the court so that it doesn't charge. But I do believe that this documentation is appropriate given the fact that Mr. Espinoza is receiving state assistance, and this was requested by the state due to his receipt of same.
Yeah, the state is requiring the prosecutor's office to do this, and I'm required to set some type of support as long as you are receiving state assistance. So either party want to say anything briefly? You're on mute.
Hello?
Hello.
I can't give something I don't have. I have 0 income right now. I'm homeless. I have nothing.
Well, you
I don't
sound
know what to do. I don't understand why this is going on. When I had the kids, I didn't go to the child support.
because you didn't what?
I don't understand why I have nothing to give. I can't give something I don't have.
Well,
I have no income at all. I have nothing. I don't have a place
You're-
to live. I'm homeless, dude.
well, did you eat yesterday? How'd you eat?
No, I didn't eat. I did not eat yesterday. I did not eat yesterday. I did not get food stamps. I did not get exercise. I have no job. I have nothing.
If you
I
have,
have nobody, dude.
if you have some legitimate doctor's statement or something that you cannot work, then she's already made it known that it's not going to start till April 1 of this year, so that you can put in documentation to the friend of the court that says I can't work and I need this eliminated. If not, then it's $28 a month, which is.
I can't even afford $5 a day sometimes to feed myself. I go days without eating without having money.
Well, the people of the state of Michigan should not have to fit the full, should not have to take care of the children with, completely, and then when got two parents who can do that. So, Mr. Espinoza, is there anything you wish to say?
Yes, I got a better job now. It's making a little bit more money, so I'm okay. I'm okay to feed my kids and everything, and I think it's okay. Like whenever we help each other,
I understand, but again, you're receiving state assistance and you got to reimburse the state some. So I'm going to enter the order. It's only $28. And if you can get to the friend of the court saying you cannot work, ma'am, then they'll look at it. If otherwise,
my Social Security was not being terminated. It was, I'm appealing it right now. I got mail. I'm homeless. I had no address. I didn't have an address. So mail got sent to me, and I stopped my check because of that reason.
well, take it in the front of the court and prove it to them. And then it doesn't even start for a month and a half on this to give you time to do that.
This is a joke. This is a joke.
So
Can you tell me what is the custody? What is it? We wanted the courthouse to put joint custody. Did that even go through?
ma'am, this isn't a custody hearing at all. I'm not
asking about the custody.
I'm not going to deal with custody. I'm going to enter the $28 a month. It gives you a good deal of time to straighten it out. If you're on SSI and that's the only thing, then take it into the friend of the court because we can't collect from SSI. That's up to you to get in there and do it. You didn't show up for a pre-hearing or anything like that. So
I didn't know. I don't have an address. I don't get mail. I don't have an address. I'm homeless. I live on the streets, dude. I've never been like this in my life.
I'm not dude, but
I'm sorry. I'm struggling right now. I'm struggling hard. I have nobody in my life. I have nothing.
Your Honor, if I may,
yes.
To potentially make this easier for the parties, Mr. Espinoza didn't mention that he has a better job currently. I can recalculate child support with that new income and continue to make the effective date April 1st and submit it via 7 days. So if they object to anything, then they have the ability to do so. I can do that, or we can enter the motion, whichever you prefer, Your Honor.
Well, him being the custodial parent, it isn't going to make a lot of difference and stuff like that.
How is the custodial parent? I see my kids every day. So they live with him. I have a place to live.
You just told me you're homeless, so they don't
My
live.
kids, they live with him, but I have full custody of them still.
Ma'am, this is about how many overnights and stuff, which you say you don't have. I'm not going to argue about this. If you say you're making a little bit more, Mr. Espinoza,
yes,
and we do this, then without going through making the prosecutor recalculate it, I will set it at $20 a month for 2 kids, assuming that father's taking care of more.
No, we take care of them.
And
we
15 for one child. And 15. Ma'am, stop. All right, I'm making my order.
I'm simply being wrong all the time.
We're gonna mute you in a second here. Just mute her. That's the order. Do you have any problem with that, Ms. DeHaan, if we just set it at 20 and 15?
Just to confirm, that wouldn't trigger the deviation when the amount does not exceed $20, correct? To deviate down to 0? My only concern, some people may read between those lines. I just want to make sure that we're on the same page.
Well, I mean, I'm making a deviation because he says he makes more. His income doesn't generally mean a lot in this custodial parent. And I'm giving, if you're afraid that it will trigger that the $20, we'll do it at 22 and 15. Okay, that'll give her credit and see what happens from there. All right.
So $15 for one child, Your Honor, $22 for 2.
That's correct.
All right, I will prepare those documents and send them to you via DocuSign, or would you prefer 7-day?
They're both here and they can hear what I'm doing. I know she objects to it, but she objects for other reasons. Mr. Espinoza, do you object to what I'm doing? I'm giving her more credit. You're on mute. We'll send you the order. It'll be 22 and 15. All right.
Thank you, Your Honor.
Thank you. We're adjourned.
Number 18, no parties.
Number 18, no parties. We're not even going very fast when we don't have parties.
I was gonna say, I thought this one.
We'll pick it up here right now, okay? I mean, I'm only through like 4 motions. I don't know what's going on today.
I think it's a full moon, to be honest with you, Your Honor.
Diesel, Pete. Yeah, all right. This is motion brought by the prosecutor's office. Mackenzie versus Blaylock. No party is present. We have set it for 8:30. It's 9:15. My question is, this was the paternal grandmother getting child support from the mother, right?
Correct.
But now the child lives with mother. Why do we even have an order?
In the event that the child does end up going back to the grandmother at any point in time, rather than it going through our office, then friend of the court can just pick up where we left off.
Oh, this is just to relieve you of another case and send it to the friend of the court and make it their problem, right?
Somewhat, but yes.
Is there a reason to believe it might go back to the grandmother?
I've had instances in cases past where, yes, this does happen quite often, where the child is essentially changed hands quite often between the parent and the grandparent.
All right, we'll enter a 0 child support order in this particular case.
Thank you, Your Honor. I appreciate it.
And you can just send that through.
Perfect.
DocuSign.
Both documents via DocuSign this morning, correct?
Correct.
All right. Thank you, Your Honor. I appreciate your time.
Are
I
you
apologize
done?
for the kerfluffle of the last one. I was
No,
only.
that's not your problem. Isn't at all. Are you done with me for the day then?
I am finished. Yes.
Oh, well, have a good day.
Thank you,
very
and have a
much.
great
Matter
weekend.
Lewis v. Jones, we have both parties present, as well as Ms. Rummel from the prosecutor's office. The first request in this was Ms. Rummel asking for a judgment of support. She has found both mom and dad have actual incomes. She's made appropriate findings as to what it is based on the time that we have. Is there anything you wish to add, Ms. Rummel?
No, Your Honor, thank you.
All right, Mr. As far as entering the judgment of the support, do either of you wish to say anything? Sir, you responded and said you guys have agreed to $300, but the amount that is calculated that is supposed to be paid by the there's nothing in here to indicate there's an appropriate deviation. So the amount is appropriate. I know you have also asked for a temporary order, but you quite frankly did not give sufficient notice to the plaintiff for me to deal with that today. What have you got? Anybody want to say anything? Ms. Lewis, anything you got to say?
No.
You agree with the judgment of support?
Of $300?
No, it's 907.
Yes.
Mr. Jones, you disagree with the 907?
I disagree, yes.
For what reason? I mean, there is nothing that there's not a deviation factor here. What are you saying?
Was I supposed to make the deviation factor? I wasn't aware of how
well, I mean, there's nothing. Why should I deviate from it?
Because from my understanding, the support amount is based off of me not being able to provide for my son, and I am able to provide for him, and I do.
No, it's an amount that is set having you take your income, her income, number of overnights, this kind of stuff, additional children. It's calculated by the child support guidelines, the computer. It spits out the number, and that's the amount appropriate, unless you can show that there's an appropriate deviation, and there's nothing that you've indicated that there is an appropriate deviation.
Okay.
All right. So that'd be the number that we would put in. However, ma'am, he filed for a temporary order. As I have said, it's not even appropriate for today because you did not have sufficient notice. Did you get a copy of his motion for a temporary order?
I got a copy of a response for today's hearing. That's it.
Well, he has a response saying that $300 and this kind of stuff. But he also filed a motion for a temporary order. You did not get a copy of that?
No.
Sir, what happened to that?
I was supposed to hand deliver it to Ms. Lewis. I couldn't get a hold of her. She wasn't at home, so it wasn't delivered within 24 hours. So I don't know. I guess I had to get it to.
I can't make her respond to a motion that she doesn't even know what it is.
Correct.
He's asking for joint temporary legal and physical custody, things like that, ma'am. So you'll have to either refile it or the two of you can figure out what you want to do. You understand?
I understand.
He'll have to refile it. All right. Then I will sign the order if it's sent through DocuSign for the 907. And I guess I'll look for the other motion at some time. All right. Good luck, everybody. Thank you very much. We're adjourned.
Thank you.
No problem. We almost done?
Wash right there.
You're
Number
very
six.
contacted when he talked to my clerk. He said he wanted time to get an attorney. This is properly noticed. I'm just telling you that because if you're inclined to allow that, then we won't go through everything, but
we are not inclined to agree to that.
all right. We now have Mr. Burkett. Can you hear me, sir?
He did not.
Doing a lot of talking, but not connecting. Yeah, Mr. Curcio, why don't you just mute? I'm gonna take another case in, but then if he gets on, then I can grab you guys right afterwards, okay? And I don't have to bring you in.
That sounds fine. Thank
All
you.
right, we'll work to get you there. Both parties are present via Zoom. This is about their son who's 17 years old, 17 in a couple months already. His dad's custody motion says he wants joint custody. Back in 2007, there was a judgment of paternity in which mother had physical custody. There was a referral for parenting time to friend of the court in 2013, but neither party appeared. Later in 2013, there was another referral. Ultimately, there was an order for father's parenting time every other Saturday from 10 to 6 and Sunday noon to 5. And where that exchange would take place in 2023, I note that there was a UCSO entered that showed dad had 32 overnights, and then in 9/19 of 23, the parties entered a UCSO showing 26 weeks for each party, 50-50 with 0 child support. I don't know what the current situation is with Darius. I do know that the claims of the father is Darius was shot in November. I believe he was shot in the foot, and that he was also apparently going to be arrested or something in January of this year. He claims that, Darius is doing drugs and the mom condones it and all that kind of stuff. And he wants 50-50. In order to even consider that, you have to present enough evidence to show that there's a Vidvarka change. What is the current situation? Where does Darius live and with who for what amount of time?
Right now,
Darius,
he's staying with his, who are you asking?
That's fine. You can answer, sir.
Okay. Well, he's staying with his mother right now. He's been staying with his mother. So, and
right.
pretty much all the time. So.
All right. Ma'am, what do you have to say about this motion?
I just feel like this is another attempt of Darius trying to get out of child support, Your Honor.
Didn't we
yes,
refer
Darius
this for
was-
child support just recently?
Yeah.
All right.
Yeah. So apparently either sometime after you ruled, he went down and filed for custody, did the motion for custody.
All right.
So I didn't receive the paperwork until Saturday. Darius was shot in the foot. It was no thing of being arrested or anything like that. He did a curfew thing where he was supposed to be at my sister's house. He left her house with my nephew while she was asleep, and the police got them. Instead of Darius coming home, he had the police take him to his dad's house because he knew that I was going to be upset. So once I figured out that that's where the police took him to, I went right over to his dad's house, picked him up, and brought him back home.
Darius attended school?
That's not
he's
true.
in school. Yes, he's in school.
What school?
He goes to Link. It's an online school.
Link
He's
Learning?
actually
Yeah.
online right now. He's online right now doing schooling.
All right. So how often do you see Darius, Mr. Keys?
Honestly, right now, to be honest with you, me and her we never got along. And it's like every time me and her have a disagreement, automatically I don't hear from my son. She goes in his phone and blocks him. And, it's just crazy. I want something from the courts basically establishing my rights as a parent. It's like she has all the control over me and his relationship. She want to base it on, you just doing this. It doesn't have anything to do with child support. I don't want this boy to be in jail. I don't want this boy to go to prison.
I don't know. Is there any delinquency petitions or anything, ma'am?
No, sir. No,
right.
sir. Never has it been. Darius is at an age. When his
almost
father finally
18.
got out of prison, he was 15. Darius is old enough to have his own relationship with his dad. He has his own phone. I don't control Darius' phone. I don't tell him when and when he cannot speak with his dad. That's between him and his father. I never, ever came in between him having a relationship with his father. That's on Mr. Keys and how he plays it. Darius doesn't have any criminal record, no truancy, no delinquents, no none of that, Your Honor. And I have been raising my child by myself for the last 17 years.
Okay, well, his father's asking basically for something. I don't know that there is sufficient. I don't know that Varka has been met to change custody, which means you have to have a change of circumstance or proper cause to even have an evidentiary hearing. I can't change custody or do anything about custody here today anyhow, really. However, I mean, are you seeking to have him? Here's the problem. If I say, okay, Dad'll have every other weekend from Friday till Sunday. If Darius doesn't go there, I'm not sure what I'm going to do. He's going on 18.
Yes.
And by the time I get through all the stuff, I'll be lucky. He'll be 18. I don't have any control over him once he turns 18, other than, you know, you can pay child support beyond that, but I have no control on where he goes. What are you asking for? I don't know that you have provided enough that would enable me to have a custody hearing for 50-50.
Okay.
But
Well, I'm just asking for, I just want summers, spring break and Christmas break. That's all I'm asking for.
Christmas break will be after his birthday, so I have no control.
Okay, well, summer break and spring break.
Well, you're asking for the whole summer?
Well, unless she sees something different that, you know, I'm willing to negotiate. This is just what I would like. I mean, I'm open for negotiation.
What are your thoughts? I should do something as far as
my thoughts is Darius is 17 years old. He's old enough to communicate with his dad, ask his dad to come and get him, go over to his dad, whatever. I don't even know how to explain it, Your Honor, because it doesn't make any sense.
No, I understand what you're saying. I deal with
I
this
can't
stuff
make
all
him
the
do
time.
anything.
I
You know,
understand.
he's at that age to where if I tell Darius, no, you can't go somewhere, I'll look up and he's gone because dad then came and got him, supposedly take him to his house, and then he'll wind up somewhere that I don't want him to be. So I don't know. And I don't know. I really don't know. Darius has a job. He goes to work. He goes to school.
Where does he work?
And he works at McDonald's.
All right.
So he just got
Good.
that job. He's actually still in training. I don't know, Your Honor. That's something that him and his dad should be able to.
Exactly. But
and that's between them. I
that's
don't
why I'm
play
here
a part
today,
into
Your
that.
Honor, because she doesn't know, but I do know that I want something that's basically saying like she's something she can't interfere with.
Well,
that's what I'm asking for.
Okay, but she might. Here's going to be the problem, and I can tell you it's going to go forward from there because it goes on with all the. Once kids get to about 16, 17, I make orders all over the place, and then I'm trying to enforce them because if I say, all right, you can have every other week in the summer, all right, and if he doesn't go there, you can file a complaint against mom, but the odds are I'm not going to hold her in contempt unless she's actively preventing him from going there. And she's saying he can go to his dad whenever he wants, basically, as long as.
Well, the thing is, she can say that, but then why am I here? If that was the case, I'm not here to wait. Your Honor, I have a job. I go to work. Like I have to work. So I'm not here to waste time. Like I'm not wasting nobody's time. I'm here because
obviously so, because you could have been brought up an issue when he was 12, 13, 14 for custody.
How
Didn't do
under the
that.
bridge, we can't go back to that.
Exactly, but
it's just to move forward.
He's trying to hold me accountable because our son chooses to do what he want to do. If I say Darius, just for Christmas, he went with his dad for Christmas.
Okay. This is
and I made Darius go with his dad for Christmas. I made him go. Darius, you're going to go spend time with your dad and his family for Christmas, and you can come back home. I made him do that.
Okay, I'm not trying to get in the middle. I'm not trying to say you're interfering, ma'am. I don't know. The two of you obviously don't see eye to eye. So what I'm going to do for right now is enter an order that says Darius goes to his dad every other weekend from Friday at 5 till Sunday at 6. Okay. Starting, do you want it to start this weekend or next weekend?
You can start it this weekend. Or next weekend because it's Friday already. We'll do it next weekend.
We have a video or not a video, in-person visit with my son.
Well, that has nothing to do with
it's already been scheduled. It's already been scheduled for March 1st.
You're right. It's
For
a
March
prison
1st.
visit. Her son is in prison. She like why my son?
It's March 1st at what time, ma'am?
We leave here at noon. The visit starts at 2:30. So he's in Adrian. And the fact of what Darius fails to realize is that my son is the one who was there for his brother, not his dad.
Well, then, you know, I don't want to go through everything in history.
I don't either, Your Honor, but he's not gonna. That's
We
something that
can
we've
start
been
it
doing.
this weekend, okay?
All right.
And then that won't interfere. All right, we'll start it this weekend, Friday at 5 till Sunday at 6. Tell Darius he's going to his dad's for the weekend. All right.
Okay.
And we'll do that every other weekend. I can also grant every other week in the summer. I don't know how that will work, but if Darius is working and all that kind of stuff, what I'm hearing from Miss Thompson is she doesn't care if I order him to go.
I don't.
So we'll do every other week in the summer, starting the first week. You get the first week after the first Sunday after being let out of school. And every other week with you, and we'll leave that now, realizing that by middle of December he's 18 and I don't do anything. So that's the order of the court. You'll have an order in your hands, both of you. How it works out is left up to, ma'am. I don't think you're going to interfere with the court order.
No. No, Your Honor.
So
No, it's not.
Let's just get him. You'll tell him what it's going to be. You'll get a copy of the
I'll
court
tell
order,
him, and if he don't go, Your Honor, it's not on me. That's I just want that on record. If Darius decides that he don't want to go to his dad's on the weekend, that's not on me.
All I want you is to tell him the court has ordered
Yes,
him
sir.
to go there. All right.
Yes,
I don't
sir.
want you to and encourage him to go. All right.
Yes, sir. Yes, sir.
Good luck, everybody. We'll send that order out.
Thank you. All right. Thanks.
He hasn't called in. He hasn't done anything, right? Did you talk to him earlier or something, or did he email you, or?
I think it was yesterday I talked. Yesterday.
It is Cook v. Burkett. Ms. Cook is represented by Mr. Curcio. She is present with her attorney. Mr. Burkett logged on, sat and never connected, sat and watched him for 5 minutes while he didn't connect. He logged off and has never logged back in. That was probably 10 minutes ago or something. I don't know what he's doing. I feel like I should go ahead with this motion. He's got to have some responsibility on logging in or calling in or something. Is there any chance that he's called your number or something?
No, I do my cell phone.
Oh, and we have it set so that if he'd called my clerk or something, it's set through the cell phone. She would know it. This is your motion, Mr. Curcio, regarding to modify parenting time and child support. Basically, it looks like it's I think you're trying to modify custody here and would have to meet, but VARCA, there was a judgment of paternity entered in, oops, no, wait a minute. Sorry, got my wrong notes here. I'm still on another page. I apologize. Per an order in April of 2022, have 50-50. And clearly you're asking to modify parenting time, but you're asking for a substantial modification of parenting time, which has to meet the VARCA standards at that point. Proper cause or change of circumstance. There are certain things alleged in here that do not warrant change of circumstance because I'm sure he didn't have his driver's license before the last order was entered and stuff like this. However, I have got documents here and there's clearly a proper cause or change of circumstance. If I can ask a question here, Mr. Curcio, I got pictures here of a kitchen.
Yeah.
And when are those from?
January 15th.
January 15th, 2024, Your Honor.
January 15, 24. Ma'am, did you take those pictures or how did they get taken?
I took those pictures. I had, it was a day that I had to pick up Malachi, and Malachi had answered the door by himself. He said that his dad was sleeping, so I had come in the house to help him get ready. And his father woke up a few minutes after that. While I was waiting for Malachi to get ready, I took pictures of the surrounding area that I was standing in.
It's my understanding that Ms. Cook understood Mr. Burkett to have been drinking at that time.
Well, I know there's substantial statements in here about his drinking. I know the initial thing was that he left his 5-year-old son in a car while he went in and bought a gallon of vodka. I'm not sure how you know that or whatever. And I guess what I'm saying is his drinking or something, it doesn't even affect me at this point, because quite frankly, the pictures of that home are so disgusting that your son should not have to be there. All right. And that it clearly provides proper cause in the satisfactory environment factor. Living in a stable, satisfactory environment, that is not a satisfactory environment. And your client's statement here to me that I'm assuming are true clearly provides enough Vadvarka to have a custody hearing to change custody. As you know, Mr. Curcio, I can't change custody on a Friday morning. So it's clear that we will have an evidentiary hearing regarding this matter. And I'm not even addressing the other pictures of your son's clothing and what he is dressed in. I'm assuming you are testifying or saying to me that those were all pictures recently taken of your son's condition when he would come home from his dad's.
Yes.
Is it a safe assumption that you don't send him there wearing that?
No, I don't send him in that stuff.
All right.
Your Honor, there have been additional escalations, frankly. I know that the court is inclined to grant an evidentiary hearing or move this along, having found that there's a change of circumstances. But I think it is important to note that Mr. Burkett actually attempted to, mitigate his lack of providing clothing for the child and went out and bought what he claimed were a pair of winter boots for the child. They were ski boots, and he sent the child in ski boots to school. The ski boots were a men's size 4. The child wears a boy's size 12. It's also important.
How much difference there is there, I don't know, but
yeah, they were the wrong size, suffice to say. There is also now, as far as the allegations are concerned, with regard to the sleep routine at dad's and the impact that they're having on the child's behavior, the school is involved at this point. The school called a joint parental meeting. Mr. Burkett initially resisted attendance, saying that whatever behavioral issues were being perceived by the school and by Ms. Cook were isolated in those locations and weren't happening at Mr. Burkett's house.
I did email him.
Mr. Burkett then feigned interest after the appointment was already scheduled, required the school and Ms. Cook to reschedule the appointment to February 8th, and then predictably didn't show up. The school has recommended, and I quote, consistency with the home schedule and routine, including bed routine and sleep schedule. Ms. Cook has gone so far as getting the child.
I'm going to make some modifications here to the current order, okay? Because I think the child, in order for me to make some significant modifications, I think I have to find almost a current, the child's in danger, if you will, being at the father's. Those pictures alone tell me no kid should live in an environment like that. I'm not going to stop dad from visiting the child at all. He does have a relationship. I'm assuming that Malachi has a relationship. He's almost 6 with his dad. But at least for right now, I think I have to make some type of modification to that. And especially if it's to the point where, where it appears to be at this point. So
if I may also add, just for the court's clarity, custody, in fact, has not actually been established in this case. Initial custody is with mother through the support matter.
Yes.
Legal custody and physical custody haven't otherwise been determined.
I'm aware of that too, that I would probably have to have a hearing whether or not you met Vadvarka or not, especially as it relates to legal custody. She does have custody, but I mean, I'm going to have a hearing on this no matter what. All right. The only question is, what do I do in the meantime until we have that hearing? Because I'm sure you know that it's not going to be next week. We're going to have this hearing. Okay. And I'm not going to have Malachi doing that kind of stuff with his dad. I'm going to suggest at this point that mother's going to be given extended parenting time, and that the father will have how about Wednesday from after school till 7 o'clock? He can visit. And And, can he do every Saturday from say 10 a.m. till, I don't know, 7 o'clock at night? Is that, ma'am?
You can do that.
I mean, again, I'm not really sure if he's gonna take him to that house that he should even do it, but he will be there from 10 a.m. till 7 o'clock on Saturdays, every Saturday. And then we're gonna deal with other things as they come up. I'm also gonna add into the order, because I did read all these text messages where he tells you he has freedom of speech and all this kind of stuff, even though you do not want contact with him except as it relates to the child, that any contact with the mother will be strictly for the purposes of dealing with the child. Okay. Because whether he thinks it or not, it is harassment to simply send other stuff about other things. And I would like that prohibited also. As far as that goes, every Wednesday, and that kind of takes care of your problem as far as school. He doesn't spend nights there right now.
Okay.
So, is there anything else I need to deal with here right now?
I might only ask that we add, for whatever it's worth to this order, a prohibition on the use of alcohol during this parenting time.
Yeah, you think that'll be successful? Yeah.
At least worth getting in there. I don't know how
Right.
successful it'll be.
Yeah, I will prohibit 12 hours before and during any time that he has the child. And you have to do more than suspect. You have to be pretty sure if he's drinking, you don't have to give the child to him. All right.
Thank you, Your Honor.
Anything else? Other than that, we'll see the two of you and Mr. Burkett, hopefully. Again, I'm just going to put on the record, he logged off. My client has emailed him. We've done everything to try and get him back. I'm sure it's been at least a half hour since we first called your case to now. He's not back on. There are ways he could call in. There are things that he could do, but this order can remain in effect. Since I can't help him, just like you saying that he said, yeah, reschedule the school thing, and then he doesn't show up. I don't know what he's doing. So this will be the order of the court at this time, and we'll contact your office, sir, to try and arrange an appropriate time for a custody hearing.
Very good. Thank you, Your Honor.
Thank you. Good luck. You'll prepare the order, please.
Yes, sir.
All right. Thank you, everyone. Have a good weekend.
You too.
You too.
Thank you. The prosecutor's office is here. Ms. Rummel is here. We have Ms. McSawby. Ma'am, you can hear me?
Yes.
Mr. Fox is not logged in at all, to the best of my knowledge, has he?
Yeah.
He was given notice. This was set for 9:30. He still is not. It was technically set at 8:30, but my clerk called and said we'd hear it sometime after 9:30. He is not logged in at all. This is a motion filed by the mother regarding ROPA to find that the father is not, well, Mr. Fox is not the father of, and I don't know how to pronounce the name of this, but this case, the case that the prosecutor's here on, Ms. Rummel, does not include this child in it anywhere, to the best of my knowledge. Correct, Ms. Rummel? I mean, I don't.
That is correct, Your Honor. We filed a complaint for support for the two older children whose initials are AMF, who's age 12, and another WLM, whose age is 16. The child that Ms. McSawby would like to disestablish paternity of is not named in the complaint.
Ms. McSawby, I can't deal with a child that isn't even in this court case. You're trying to bring in somebody altogether different. Are you married to Mr. Fox or what?
Yes, but separated for almost 10 years.
Okay, but you're going to have to file something in some other case if you want to find that he's not the father. There's no child support order. There's no, I mean, he's obviously the father by the act of marriage, but this case doesn't even deal with him. And so there's nothing that I can do in this case. It doesn't even deal with this child.
I was just trying to file for child support for my two older boys and not pursue child support for my one.
That's what Ms. Rummel is doing.
Okay, I was under the impression that I wouldn't be able to move forward with the child support case unless I establish that he was not the father of my youngest child.
You can talk to Ms. Rummelt afterwards, but Ms. Rummelt is only asking for child support for the 2 kids.
Yeah, for the 2 older boys.
Yeah. So I don't know what you're doing with the other one, but I'm not going to grant your motion because the child just isn't part of this case at all. M is not a party to this case at all. So Ms. Rummelt will finish her work regarding child support on the other 2 children, and we'll either be back or you'll have some kind of agreement on it in the near future. All right. Ms. Rummelt,
Okay.
correct that?
Correct, Your Honor. I do not know why the youngest child was not included in our complaint. It might just simply be by the age they kind of slipped through the cracks. There could be a referral in the future for that child because you're still legally married to Mr. Fox. But I think we can cross that bridge when we come to it.
Yeah, and you may want to talk to her and figure something out in the meantime or whatever. Okay, and because she's saying that's not the father, we'd have to have him tested. If you want to get involved in the youngest child, then so be it. But it is not a part of this complaint or anything to do with this. So I'm going to deny your request for ROPA at this point because the child, I don't really have any jurisdiction over him. Nobody is asking for it. Yes, you can. Okay. You can bring. Good luck, everyone. Thank you.
Thank you, Your Honor.
You want me to just in?
Denied it because there's nothing to deny, and he's not connecting. You can log him off. He's not connecting again. Hello? Ma'am, can you hear me? Is she not connected? I thought you said everything was going smooth when I walked in here today.
It was fine.
I showed up and it all went down the toilet. We have Mr. Johnson Powell on here, although he is not,
trying to.
We can't see him. He can't get his video yet, but I'll call the case. Matter Beitner versus Johnson Powell. This is father's child support motion. Says he hasn't worked since October of 2020. Other kids, he has a wife with 4 other kids. He was imputed at income at $16 an hour times 35 hours. Ma'am, you know he has 4 other kids?
No, I knew he had 2. I knew he had 2 little girls. I did not know he had 2 other kids.
Sir, do the kids live with you?
Yes.
All 4?
Yes.
So you're living with your wife and 4 other kids?
Yep. Yes, sir.
All right. It's appropriate that we make an adjustment on the child support order to include that. However, you're still going to be imputed income. How do you live if you've had no job since October of 2020?
Well, I went to barber school for about right after that. I went to barber school, graduated barber school sometime in July. From there I was cutting hair, but I couldn't really get into this shop because I had a house I was working on. And after that, I just recently started the apprenticeship program at the Millwrights Carpentry Union. How
much are you paid there?
Well, I'm not actually paid because it's an apprenticeship. You have to find work while you're going there. I just started in January. So you got it's an apprenticeship. You go to school 2 weeks, every 2 weeks for the next 4 years.
I guess my question is how do you feed the 4 kids?
Well, I'm working under the table. Why she has a part-time job, but I'm not really. I don't have a job.
Well, at this point, the factors in the child support appear to be correct in imputing you with an income because your first obligation is to support your children, both the 4 kids at home as well as the child that Miss Beitner has. That's your obligation, and that's just the way it is. The only change I'm going to make to this order that you have asked for is you are to be given credit for 4 additional children, which will lower your child support, but I'm not sure how much at this point. You do credit at this point for, I'm not sure, I think it's 1 child. I don't know. You're given credit for $346. I will check with the friend of the court to rerun the guidelines, giving you credit for the 4 children as opposed to however many they've given you credit for right now.
Is there a way to get this moved to Wayne County?
Wayne County, no.
Yes, because from what I was understanding that neither one of us is a resident of Kent County, and we also had a pending case in Wayne County with the case number being 1. I was told.
And where do you live, ma'am? Why are they doing child support here?
Because I recently moved from Kent County, and I reached out for assistance, and I was denied assistance because of the non-compliant with child support. And so I was reached out by the prosecutor of Kent County, and she stated that she was going to open my case in Kent County. And so I've just been working with Kent County, communicating with Kent County, and also with the Wayne County DHS office, and there hasn't been a communication problem or error or anything.
All right. I will reach out to the friend of the court and see what their thoughts are, if they want to transfer it, since you are both in Wayne County and not in a contiguous county. I will see what they wish to do with it. But at this point, other than changing to give you credit for 4 children, whatever that comes out with, that's what I'm going to enter at this point.
Okay, sir. It is my understanding from the paper I received from the prosecutor that her address was still in Taylor at the time of the my first letter.
Yep, my prosecuting office came from. Yep, my address is in Taylor. The prosecuting office. I spoke to the lady, told her that I lived in Taylor, and that's why I've been getting Kent County mail sent to my Taylor address with no issue.
You're fine. You're fine.
Thank you.
All right. I'll rerun that at the appropriate amount, still giving you an imputed income. But I will run it so that you have 4 children, as opposed to, I'm not sure how many they put in here. I know they have given you credit, just like they've given the mother credit for having additional children. You will be given credit for the 4 children. We'll rerun that amount and send it out as an order. All right.
What will be my? Will they still run me as having a job if I don't have one, or how?
Yeah, because you're imputed as income. You can't come in and say, I'm not working, I don't have to support my kids.
Well, okay. Well, how could I adjust that if I'm not working? How could I adjust that?
You're never going to go to 0 unless you have a doctor's excuse saying that you are unable to work.
Okay. Okay.
Otherwise, you are imputed as income, and it's, as of right now, I think we've imputed you at $16 an hour times 35 hours. Anybody nowadays can get can work 35, 40 hours a week. And you do have a prior history of employment that includes that you were in the military, but you also had, looks like, the United States Postal Service, where you were earning more than $16 an hour. You are a high school graduate. You are available for work. Don't know why you're not working. So that's, I'm going to impute you at a minimum of $16 an hour and 35 hours. It should be more at 40 hours, but I'm only going to do it at that right now. So you've got to have a job. You got to support your kid. I mean, there's no reason a mother should have to pay for everything. It's your child. So that's what it's going to be, ma'am. We'll send out the order when I recalculate it. All right. His support is going to go down. His support is going to go down because he's got other kids. But
right,
it is what it is.
Yeah, Your Honor. Honestly, Jackson is almost 9. Jackson will be 9 this year, and me, my mother, and my fiance have been taking care of Jackson the past couple of years with no complaints. So it's completely understandable. I mean, it's not going to make a difference, but I appreciate your help. I do. I really do.
We'll see what we can do, and I will talk to him about possibly transferring the case.
Okay, thank you so much.
Good luck, everybody. Thank you. We're adjourned.
All right, bye-bye.
And I guess
I thought that it was going to be so easy. DS. Miss Avery is present. All right. Mr. Cappy is not. This was set for 8:30 and we're almost a quarter after 10. Mr. Cappy is apparently never logged on. Is that correct? Ma'am, how did you does he have notice of this? Did you send him a copy of this motion?
I brought it to his house personally.
Was he there?
Yes. I wasn't expecting him to be here today.
So you handed it to him?
I put it in his mailbox.
But he how long ago was that?
Right when I filed it to the court, I drove to his house that day. Put it in his mailbox because I wanted to make sure he got it.
You say you filed this, I think you signed it on January 27th.
Yep, so that would be the day that I brought it.
You brought it right to him and he knew it was there. Have you had any conversation that he knows this is here today?
No, we haven't spoken.
All right. It appears that well, it wasn't technically personal service, it was clearly service. like more than 3 weeks ago. And he is not shown, so we will proceed with this case. This is the request by the mother for custody. Ma'am, I think the only custody that has been given so far is to you in the DS case. It says initial custody to mom without prejudice of either party filing for a court determination of custody. I'm surprised you filed because you do have custody right now. But,
right. Yeah. And sorry, sir. So I did speak to an attorney after I had filed all this, and he explained to me that he was like, oh, because you signed an affidavit of parentage when you had your children with him, that you already have full custody. And it's to my knowledge that that's kind of a mushy area.
Well, yeah, hold on a minute. Yeah, you don't necessarily have full custody. It's not a judicial determination of custody.
Right.
When you had this DS case, which is a support case, probably filed by the prosecutor's office, they include in their order that you are given initial custody. And it says the petitioner mother has initial custody of the child without prejudice of determination of either parent's custodial rights until otherwise determined by the court or agreed by the parties in writing and acknowledged by the court. So you do have an initial custody, but I don't know how to say it. It's not a strong custody. He could come back and ask for custody based on, without any Vadvarka factors. You can ask for it also, and I think you're asking for it. I've read your motion based on allegations that you make of him. You don't think his home is safe. There might be domestic violence there, drugs present in the home, children home alone for long periods of time. Your children are 4 and 6, so that would not be appropriate. There are other allegations that I'm sure if he was here, he'd deny them, because that's the way this goes. All right. However, you are asking for legal and physical custody, and I can't give it to you on a Friday morning. I can only have a hearing for it. Okay. I have to have an evidentiary hearing. I think under the circumstance, before I have a hearing, why don't I refer it to the friend of the court so you can give them all that information and go through stuff and see what they have to say. They may be able to, what they will do is they will go through, make a recommendation, and if either party objects to it, then I have a hearing. If not, you might get it settled through them. You'll get a chance to provide the friend of the court everything that you need to provide them as to why you think it's appropriate. We'll refer it for legal and physical custody, as well as parenting time and child support. And then they'll do a whole report. You don't have an attorney, so I think this would be a better way to go at this point. Okay.
Okay.
And I'm going to refer it. I guess I'll waive your fee that the parties have to pay for it. It's $150. Otherwise, you're raising 2 kids. I don't know if you're raising them on your own or what, but is he paying any child support?
Yes, from the beginning, he's paid me less than $100 a month.
All right.
All right. And he hasn't been helpful. So,
do you have $150 or not? Here's what's going to happen. If I charge each of you $150, he's never going to pay it. And
right.
And then it's going to come back as either dismissed or you're going to have to pay all $300. So I'm just going to waive the fee. All right.
Okay. Appreciate that.
And you will get information from the friend of the court. Make sure you cooperate with them, because they're going to do their best to try and figure out what is appropriate. All right.
Okay. Yeah.
Any questions?
So I guess I was just confused because I thought making the custody legal had to go through the court here, but it's really through the friend of the court?
No. It will come if you guys can't agree on an order, okay? And then I'd sign that. If you guys are not going to agree on an order or something, then I'll have a hearing, but I'll also have the benefit of the friend of the court's investigation also. You've made a lot of allegations against them and stuff like that, and they should do some investigation, and we'll see where it comes out. Okay. And then in the end, the court will, either through agreement of the parties or through my order, will figure out custody, both legal and physical, parenting time, what is appropriate, as well as child support. Okay?
And also, I recently got a recommendation for child support back from friend of the court that I did ask for back in December. So I do have that now. Does that go into effect?
I don't know if they're going to, I'm not sure where that's at. Okay, I don't have it here. All right. So generally speaking, if they did an investigation and recommend an amount, and if neither party objects to it within a certain period of time, I'll get it to sign it, or Judge Hillary will, and it'll go into effect. And I don't know what the effective date is on it. It's probably effective sometime shortly after you ask for it, as opposed to right now. But I don't know. I don't have that in front of me. All right.
Okay.
We'll get to the bottom of this. It's just going to take a little bit of time.
Okay, yeah.
Because otherwise I got to set up an evidentiary hearing, and that will take time too, and you'll need an attorney for that. All right.
Okay. And then one more question, sir. I don't believe that he is going to cooperate with the court or friend of the court with any of this going forward. Does that change anything, or do we still have a hearing? And
we'll see what happens. They say you go to the friend of the court, they make a recommended order, and he doesn't object to it or do anything, and you're fine with that order, I'll probably just sign it.
Okay, sir. Thank you.
All right. Just understand, read the stuff from the friend of the court, do the stuff with them. If they say, well, because I've made this, it's not going to automatically go in, you may have to file a motion or whatever. Just read the stuff you get from it. Okay?
Yeah.
Okay.
Yep.
Good luck. I'll make the referral.
Okay. Thank you, sir.
Have a good weekend.
You too.
Can you hear me now?
Yes, I can. How'd you get this motion to Mr. Michaels?
Mailing.
Do you remember when?
The same day. I can look at my paperwork really quick.
Well, it was scheduled a while ago. Did you send him a re-notice of this then?
Yes, it was mailed twice. The first one I had missed it, and so I don't know if he made it or not, but I redid it and then sent it again on the same day that I refiled.
Okay, it says on the 13th of
February, I believe.
this month, which is appropriate as long as you mailed it on the 13th.
Yeah, I mailed it the same day that I filed it.
All right, it's a matter of Chipman versus Michaels. This is a motion by the plaintiff mother who is present. I don't want to say mother, Miss Chipman, who's present. Mr. Michaels is not. This is a re-notice from a couple weeks ago. It's a motion to enforce the judgment of divorce. The judgment of divorce was entered in January 17, 2024, in which she was entitled to the 2000 Silverado. She says that the defendant has not returned the vehicle. She has no way to get it from him at this point. Is that still the case?
That is still the case, yes. I have tried to go by the house. The vehicle's not there anymore. I'm not sure where it's at. He's blocked my contact, so I don't have a way to try to communicate anymore. So I contacted the legal aid center to try to get help. I contacted the non-emergency police number to try to get help, and everyone's just telling me to redo the motion and try to see what the court says.
Well, I don't generally do an order to say, something that's already ordered, which is in the judgment of divorce. You get the Silverado, but he is to return the vehicle to you by March 1 of 2024 or face contempt or other such appropriate proceedings. This is going to get a little bit more difficult for you if you're going to really proceed. How much do you think that vehicle is worth?
It was around $4,000.
Yeah. Okay. Well, if he doesn't return it by March 1st, you're going to have to try and figure out how to proceed. And my problem is I can't give you a lot of advice, but I would suggest that you provide information as to the value and not make it just that I think it's around $4,000. You're going to have to provide something to the court, okay, that shows its value is approximately that. If worse comes to worse, well, I'll end up probably giving you a money judgment and some other remedies. I can hold them in contempt, but you don't put somebody in jail for money, but ultimately, if he doesn't give it to you and you want to pursue it far enough, probably can get a money judgment if he doesn't return the vehicle, because whose name is it in?
Both of ours.
Okay, so it would seem like he probably couldn't sell it without your signature on it too.
Correct.
But that's not to say that he hasn't given it to somebody who knows where. But I mean, if he's not going to do that, you can continue to, I'd be willing to probably give you a money judgment for whatever the value is, and you could start garnishing his wages and taking things from him. I'm not going to let him get away with it, but I'm not going to go out and look for it myself. All right. So
okay.
I will give you the order that he's to return it to you by March 1st. So then you can start other enforcement proceedings after that if you don't get it.
Okay, so if I do happen to find it, because I have been actively trying to figure out where it's at, what do you recommend I do at that time? Do I call the non-emergency police and see if an officer can come out and assist me to get the vehicle?
I can't give you much advice. I'll just tell you that if he hasn't returned it by 3/1 and you find it, you can take the order to somebody like non-emergency police and say, look, at this vehicle is mine. I don't know what they'll do.
Okay.
We'll send you that order that it is to be returned to you by March 1st, because I'm not sure in the judgment that there gives a date when he's actually supposed to return it. This will make it more certain. Okay.
Okay. Thank you.
It's the best I can do. You're in a bad situation, but if you want to pursue it long enough, you may want to talk to an attorney. I know they'll charge some, but you might even be able to get their costs too. All right. He's not going to just get away with this unless you let him. All right.
Thank you.
Thank you. 287 DC, both parties are present via Zoom, as well as Mr. Swears on behalf of the defendant, Mr. Furtado, who has made a motion to the court regarding child support. It appears that, well, and I've read the motion, I've read the mother's response. It appears that everybody understands that as long as Mr. Furtado is back working in Brazil, he works for the government overseas. When he's posted overseas, he makes a lot more money than when he's at home. To the point where I understand, he earns $100,000 more when he's overseas than he does at home. And he has been returned home. And I don't know, I'm assuming that at some point in the near or somewhere in the future, he will be returned to some type of overseas, but he's not there at this point. The last I know is he was returned to Brazil from Botswana in December of last year. Mother's response was that, child support is based on 63 overnights and he only did 9 overnights. She wants to include that he's got a partner that makes an amount of money. Ma'am, I'm not going to include any of that. That's not appropriate, nor will it ever be, unless you want, when you get married, your husband to be included in it too. But I'm not going to do that either. Complains that he made several trips, that he shows he makes more money. But you do acknowledge that relocation home does significantly reduce his income. Mr. Swears, you can add anything briefly if you want, but I think I know what is going on.
I don't think there's much to add, Your Honor. I would just comment on the overnights. Botswana has not signed the Hague Convention on International Child Abduction. That was an issue last year, so that was a causal factor. Obviously, Mr. Furtado is now back in Brazil. Brazil is a signatory, but just for some context for the court, that was an issue that was resolved between the parties last year. But apart from that, I think the court understands the issue here, and hopefully our client will in the not too distant future, I know he's interested in being posted back to the United States where he'll be both closer and make a lot more money. So we'll just keep our fingers crossed on that.
Ma'am, what's your response?
I would disagree. We did have an agreement and he went to Vancouver, Canada for 2 weeks after having the kids for 9 nights, and they are part of the Hague Convention. And in our agreement, he's allowed to see the kids anytime he wants. He never reached out to
Not when he's in Botswana, he doesn't. Okay. You would not send them to Botswana. He doesn't. That's the hit. You don't want to send them there because if he kept them, you couldn't get them back.
That's not true. They went to Botswana the previous summer.
All right. Well, as Mr. Swears points out, unless the parties agreed to it, but that's secondary. Anyhow, what else do you have to say? He earns a lot less money. Why shouldn't I review his child support?
There's a lot of income that he can earn that might not be shown. There was, again, almost $12,000 that he received for just having to move. In the future, he's able, if he chooses, to go on short missions, 1 to 3 months, up to 6 months, where he can easily earn $10,000 a month up to him. if he chooses to do that. So there's a lot of future income that can easily be unaccounted for. So it's not where this is what he's going to make.
But this is what he's making.
I mean, that's what his paycheck shows. I don't know. I mean, I saw the one stub that he produced for the motion. I don't know how much he's making.
Well, yeah. You have evidence that he's making other money?
Well, there was other accountable, like I just said, the rental, he gets different allowances.
Mr. Swears, anything you want to say?
The rental, Your Honor, it's not reflected on the December paycheck while my client was in transition. The December pay stub, which I haven't had translated yet other than unofficially, it is deducted, so it's not an additional income benefit on top of it. And I think the court's really highlighted the issue here is, if my client does get reassigned or is able to do some of these overseas assignments like Ms. Furtado references, this may be a situation where we have a few more modifications than normal. But it's speculative. We don't order National Guard members to deploy additionally because they can earn overseas. It's the same issue here. So this is what the income is right now. So we just asked the court to enter. I would note for the court's reference, though, there was, it's not contained in Ms. Furtado's response, but she did send me some additional information that I did make one error on the calculation with regards to her city and local income tax, and then she's earning a little less in rental income than we had originally had last year. So I did recalculate, and that does adjust the proposed child support to about $381. We would have no objection to resubmitting that corrected. It's about $20. We're obviously not going to run a hearing on that.
All right. Well, the motion appears to be correct. I mean, I can't, it's not like he's just saying I'm not ever going to work and I want zero child support. He's working. I don't know what the Brazilian government's going to do with him. If the Brazilian government sends him back to the United States, well, and ma'am, you will know where he is because he's in contact somehow with the kids and stuff like that. So if he is posted out of Brazil, he clearly makes more money. You can come back in and we will adjust it accordingly. But other than the adjustment that Mr. Swears has just indicated for appropriate, that you are earning a little less and that he did not include apparently some taxes or something, and it makes it up to $380. Is that what you said? 381?
It's 381, 382, Your Honor. I don't have the calculation for me.
I believe that is appropriate. I will sign that when it comes through. What is the start date on it?
I believe my client filed the petition. This originally went to the FOC. They do a great job in most cases, so they didn't quite know what to make of it.
December 14th, Your Honor.
All right. Well, it'll start January 1.
Yes, Your Honor.
And it will be modified as you have indicated. You can send that to me and to Ms. Furtado. Ms. Furtado, I'm going to sign that based on the new documents. If you have something else you want to object to, you can object to it. But I believe the amount is appropriate, at least temporarily, because I'm sure Mr. Furtado would love to make significant amount of money more and get posted to probably not Botswana, would probably rather be posted to California or something like that, but we'll see what happens. Mr. Furtado, I'm going to say you do need to notify as soon as you are posted somewhere else other than there, okay? And we will need to make an adjustment, and I want you to be, tell me what you. Is it the same amount that you generally make no matter where you're posted to?
There's a range, Your Honor. It goes from $4,000 a month to up to $9,000. Maybe if I go to Afghanistan or Iraq, it depends a lot on the posting.
I imagine you're not asking to be posted to Afghanistan, but
I'm asking not to.
Yeah, I would think so. As far as the Mr. Swears, I don't know what the difference is if he's visiting less. It doesn't usually make a difference once you get down below about 70 overnights. What's the situation? Is there going to be more parenting time that he's going to exercise or what? Because I'm also not going to give him 63 overnights if he's not going to be exercising 63 overnights. Your argument for Botswana is I can't do anything about it because they're not a signer of the Hague Convention.
I think the best short summary of this, Your Honor, is Last year, there was a significant amount of negotiation going on between myself and Ms. Judd, who at the time represented Ms. Furtado regarding resolving this case. Obviously, Ms. Judd, very competent counsel. There were just delays that made it impracticable to exercise the normal summer parenting time. By the time that case was resolved, it was resolved 15 minutes before it went to an evidentiary hearing with Judge Hillary. Our expectations, the 63 reflects what our client will be exercising now that we don't, I mean, to some extent last year, it was a coming with your hat in your hand. Ms. Furtado has, again, permitted the children to exercise in Botswana. I don't think she's weaponized this. I don't want to give the court that impression. Everything I know of this case, I would expect the 63 to be a pretty accurate estimation of what we expect parenting time to be.
Is he looking to get parenting time like at spring break or summer or what?
It's mostly concentrated at summers and at certain break periods, simply because of the flights and the amount of distance involved, Your Honor. So
that's all taken care of that I don't need to.
Nope, that is all contained in the previous order, Your Honor. And again, now there's no Hague Convention issues, so we won't need to.
All right. There will be if he's posted to Afghanistan.
There is also a Brazilian embassy in Pyongyang that we're hoping he's not posted to. But if the court had a couple extra hours, and I know from watching this morning the court does not, Ms. Judd and I have had extensive conversations. I've learned more about the Brazilian Ministry of Foreign Affairs and their general employment practices than I'd ever expected. My Portuguese remains non-existent, however. So
as does mine. So good luck, everybody. Ma'am, you'll be getting more child support in the near future.
No, I do have a question, sir.
Yes.
With our child support agreement and our whole agreement, it goes also the plane tickets, and it goes based off of the child support calculator, the percentages. And I'm curious now, because this will put me probably at 80% to 20% or whatnot, how I'm supposed to pay for.
What is the current support? I mean, what is the current understanding? Does he pay for part of the tickets and she pays for part of the tickets?
It goes based off of I'm sorry, go ahead, Jordan.
No,
Your Honor, this was one of the big holdups that took us until the end last year, was trying to figure out, because we knew this relocation would be coming sooner or later. So it is right now automatically tied to the same income percentage as the uninsured healthcare expenses. The uninsured healthcare expenses aren't as much of an issue. There's the children qualify for Brazilian health coverage. But so that is an automatic point that was significantly negotiated between the parties as part of the judgment of custody. And it's also one of the reasons that we're doing fewer trips rather than more, simply due to the cost of flights, to try and make that manageable. So there are a number of provisions in the judgment of custody designed to help reduce the cost, to try and help plan on travel, try and give some structure. But it was a specifically negotiated and contemplated part.
I'll tell you that, I mean, because of his fluctuation and stuff like that, I don't really want to stick her with a whole bunch more airline fees based on that. I mean,
it does cut both ways, though.
If I may,
makes the additional money, then he's covering more. And what we, frankly, what we tried to avoid here was coming back on motions before the court every year for the next 10 years on splitting airline fees. So, I mean, this is one of those things. I mean, certainly if Ms. Furtado wants to try and reopen that portion of the consent judgment, she's welcome to file a motion. I would just simply point that that's not really in front of the court right now. It was a very extensive.
And I guess if anything, I don't give advisory opinions. Okay. But, I have enough information that if I have to deal with that, I'll deal with that. It doesn't sound like there's an imminent. When is the next time that the kids are going to apparently see Mr. Furtado? Has that been worked out?
June 5th, Your Honor.
June 5th?
We have already agreed on dates.
Okay. And
for 63 nights.
Okay.
Tickets are booked.
And you're going, well, unless you get posted somewhere. All right. That's fine. Good luck, everyone.
Thank you, Your Honor.
And ma'am, he's going to send you a copy of that revised UCSO, okay? Because it is to be revised according to what we just discussed here. All right. Good luck.
Thank you, Your Honor.
Thank you.
Thank you.
Ham versus ham. Oh no, Mr. Gordon. Sorry, I didn't hear that.
He says, "Oh, Mr. Gordon."
Never miss a chance to do that.
I know you don't. That's okay.
Both parties are present. Ms. Ham is represented by Mr. Gordon. This is Mr. Gordon and Ms. Ham's motion for custody parenting time. Looks like back in 2019, there was an order that gave 50-50, I think. As of 2023, let's see, there's a UCSO. There's remarried, paying 104. There's an argument. The son is 16, isn't he?
Yes, Your Honor.
Okay. Looks like there was an argument. Alex, the son, went to his mom's, does not want to return. I have read the part and that says he did put, I've got pictures of his items being put out in the driveway that he's to come pick them up, or the garbage truck will pick them up. I think that in and of itself probably forms enough for Vadvarka to be met.
Yes.
In this case, Mr. Ham, you didn't respond. What do you got to say?
I filed multiple motions with not motions, front of the court complaints that they were going to file on my behalf. I think Ms. Ham is very, Karen would be very aware of that at this point. As far as his things being put out, he asked me to put those things out, and I did so about 15, 20 minutes before he came to pick them up. They were stored in my garage.
Well, no, they're not stored in your garage. They're stored in front of your garage right at your garbage bin. And you basically say, come pick them up or else the garbage. If they aren't picked up by Friday, it will go with the trash.
I did say that, yes, but
your things
I
will
only
be
put
ready
them
to
out
grab by
prior to.
tomorrow after school. I will leave them at the end of the driveway for you. It's all packed up for now and ready.
Yep. As he wanted his things, yeah. Also, we did have a disagreement, and unfortunately it led to a small argument. Miss Karen never bothered to call me. She called the police, came over, grabbed Alex, and left without any comments. And there was nothing I could do about it. I couldn't physically stop him, or I wouldn't even try at that point. And Alex has refused to talk to me since.
And so what do I do with a 16-year-old who doesn't want anything to do with you?
Cognitively impaired 16-year-old, it's very difficult, unfortunately. I think he's better off, unfortunately, living over here full time, getting some counseling since his mom's been degrading me behind my back. And
how do you know that?
They're not true.
If it's behind your back, how do you even know that?
Because Alex reported that to me.
Oh, this is a cognitively impaired 16-year-old.
That's correct.
All right.
And upon requesting confirmation from Karen of why she would do that, she refused to reply within over a week's time.
Why she would do what? Pick up your son because your son called?
No, degrade me behind my back and the things that she said.
You haven't had contact with your son since you put his stuff out.
I have texted him. In fact, I asked him if he wanted to fill out a form, wanted me to fill out a form for him for the Kent Career Tech Center. And he said, no, I will do it.
Well, Judge, and I'd like to add to that a little bit because I actually have that text. And what Mr. Ham said was, if you don't live here, you can't go to Rockford any longer, which is not true. And so I think Mr. Ham's continuing to try to manipulate Alex and saying things that are just not true. And so I didn't have a chance to include that because I just received that text from my client the other day. But that's what he said. He's like, well, you know, Alex, you can talk to everybody at Rockford. If you're not living here, then you're not going to be able to go to Rockford. My client has every intention of keeping him in Rockford. He's very happy with going to Rockford. He's just not happy at his dad's. And he does have counseling. The counselor knows of what has happened. And that's what I would recommend, Your Honor, as part of the court's order, would be that Mr. Ham have parenting time through the counselor and try to work with Mr. Griffune, and who's been counseling with Alex. But my limited understanding is that Mr. Ham involves himself even in the sessions with Alex. And I think Alex really needs to have his own confidentiality with the counselor. And I think maybe then if Mr. Ham can tone it down a little bit, he can help build a better relationship. The other thing that I want to add, Your Honor, is there is no child support in this matter that's going to go back and forth. My client is on disability, and so she already receives the disability. And I think even if Alex were to live with mom full time, it's not going to cost Mr. Ham any child support. He's not going to pay any child support to my client, and it's not about the money. It's about Alex. And there's other issues with Alex. I think Dad views Alex, and Alex is in a special ed program. And from talking to my client, she wants to get him out of the special ed program. He's a very smart child or kid. He's 16. He's able to change brakes on a vehicle she's telling me about. So she wants to have him reassessed because he understands that if he stays in the special ed program, he's going to get a certificate of completion and not a GED. And she wants him to have a high school diploma. So there's some issues about that. But I think it's unfair for Mr. Ham, who put his son's stuff out in the garbage, to minimize it. And then now he's blaming mom.
I'm not going to minimize that. That told me right there, sir, that when you put that stuff out and the text that goes with it, you were kicking them out. There's no question. You don't do that stuff. If they aren't picked up by Friday, it will go with the trash. That's about as straightforward a statement of somebody kicking their son out as I've seen in a long time. And so I have no problem that there is Vadvarka to look at custody. I understand that. The only thing that bothers me the most is he's 16 and a half. Okay. If we go through a whole custody hearing, he'll be 17 by the time we even get there. And where's he going to go and what's he going to do? And Mr. Ham, you can file all the violations that you want because she's not following it. If you guys can't agree, it'll come before me for a contempt hearing, and I'll listen to what people say, but I've got this right in front of me that you kicked them out. Okay. You're gonna have a hard pressed time saying she's stopping parenting time when you kicked them out and he knows he was kicked out. And I don't know how you expect him to just say, okay, sorry, that was fine. All back. You got to figure this out. What I would rather do than have a custody hearing is send it to mediation to see if somebody, because this is really appropriate for mediation. I don't want your son not to have any contact with you. I want you to figure out how to have contact with him. And I don't know what the situation is at your house or her house or anything. What I'd really like to do, and it's only if, I mean, I know Mr. Gordon can be reasonable. I don't know whether his client can or whether you can, Mr. Ham. Go to mediation and try and work something out where you get some time or figure out how to do this and work your way back and what those things are. So my thought is before I have a custody hearing, because I do find that there is Vidvarka to have a custody hearing. It's clearly present from the fact that it's a change of circumstance where dad kicked kid out. And I don't know what kind of time he was thinking he was kicking him out for or whatever, but I saw the stuff out in the driveway too. His guitar, I think it was, and a TV and that kind of stuff. So I find that there's Vidvarka. I would like to set up mediation before I see if I need to schedule an evidentiary hearing. Mr. Gordon, will your client go to mediation?
Yes, Your Honor.
Mr. Ham, will you go to mediation? I'm going to order it whether you do or not, but.
I will.
Any ideas on who's an appropriate mediator? We can do Mary Benedict because she's relatively inexpensive. The costs will have to be split by the parties.
Yeah. How about Sean Perry? I think she's helpful.
Sean
I know
Perry
Mary
is also
Slam
is also very.
Yeah, I think she would be helpful as well and be able to communicate with both parties pretty well. So Sean, I think, would be very good. Miss Perry.
Sir, do you have anybody in particular that you don't want or something like that?
No.
Then let's enter an order that the parties will be referred to Sean Perry for mediation. It should occur. It'll occur a lot faster than if you're going to get an evidentiary hearing in front of me. I'll guarantee you that. Then if it does not work, I can have either party, but Mr. Gordon knows how to contact my clerk better than anybody in this screen. All I would ask is that you contact and say, no, we're not able to reach any kind of an agreement. Therefore, we need the evidentiary hearing because I'm ready to set an evidentiary hearing based on the finding of Vidvarka. All right. And so I'm not going to change any order in this case at this point because I'm not really allowed to. But sir, you can file the complaints that you want with the friend of the court. I'm telling you that it's unlikely that until we get through something, if Miss Ham interferes with parenting time, if Alex wants to go see you and she interferes with it, then I'm gonna, you know what I'll do, Mr. Gordon. You better advise your client. All right.
Absolutely. Yeah, that's not going to happen.
But I don't.
He's trying to encourage it. That's why I would suggest going with the counselor because I know Alex has seen Mr. Griffune for a while, and he actually confided in him about what recently happened. And I advise all my clients, including Miss Ham or Miss Canoop, I'm sorry, that the court encourages and has to legally for the child to have a relationship with his father.
Yes.
And so that's really what I recommend. And I agree with you. She's not going to stand in the way. But I can say, that's the reason that I put it on the record, is Mr. Ham needs to consider what he's sending to Alex. And if you're sending texts that say you're going to lose out by living with mom and you can't go to Rockford, well, that's not true. He's going to stay going to Rockford.
Actually, it is, if you don't mind me interjecting.
Well, I don't think that's going to happen. He's going to stay in Rockford.
So either.
Yeah, that's where he's going to stay. And so if Mr. Ham could not send that and be more productive about how he loves his son, he misses his son, my client's going to encourage that. And maybe Alex comes around. I've also explained to my client that Alex is going to be 17. And sometimes, the kids flip back and forth. Right now he's not getting along with dad. But the best thing for Alex is to get along with both of his parents. And that's what I'm going to try to do with my client.
And I will ask you, Mr. Ham, to make appropriate contact with the counselor. If, you got to become involved to the point where if you ask the counselor, hey, maybe this isn't working or what, you can talk to the counselor about it. Okay, I'm not going to let you be the counselor, but this is all a give and take. He is less than a half a year from being 17 years old, and I'll sit and still enforce orders, but I don't know how when they're 17. If he says I'm not going to see mom today, what am I going to do? I don't know. Does he have his driver's license?
He does.
Yeah. I mean, geez, Pete's wherever I send him, he's out of the drive off. But
Right.
let's go to mediation. The parties have to mediate in good faith, all right, to see what type of agreement that they can come up with that's best for Alex. If not, I'll have an evidentiary hearing. We'll schedule it. We'll figure custody, parenting time, child support, anything that's appropriate.
Okay.
All right. So, Mr. Gordon, if you would draft the orders that would make Ms. Perry the mediator.
Yes.
You can also, I mean, if you want to put in there that father can have full access to his counselor, that's fine. You do have access. Do you know the counselor, sir?
Me? No, I do not. Not very well,
Well, I mean,
but I do know who he is. Yes.
All right.
I bet he sits in with the sessions.
He says he knows who he is. He just doesn't talk.
Well, that's not my understanding. My understanding is that he talks to Mr. Griffew. So I don't know if that's accurate, but I will put that in the order, Your Honor. And I will do everything to keep the door open. I'm not trying to ruin his relationship with his son. That's not my job. That's not what I intend on doing.
Plus, at 16 and a half,
Right.
none of us have a lot of control.
Right. Right.
All right.
Absolutely.
And that's just a fact of life.
Yes. Right.
But I'll do the best I can to enforce things and keep it moving in the appropriate direction. So mediation, contact with the counselor. I think that'll do for right now. That you can put in there that I have found Vidvarka.
Okay.
And if need be, I will schedule an evidentiary hearing, but I hope I don't. I hope these parties can get along well enough. Good luck, everybody. Anything else?
No, Your Honor. Thank you.
Mr. Ham, anything else? Ma'am, you're not part of this.
Sorry, tell him.
May I interject about Rockford schools anymore, or is that
Are you going to try and get him kicked out?
No, I'm not going to try to get him kicked out at all.
All right. Well, the prior order was like 50-50 and he's just not with you right this minute. Why would Rockford kick him out? Why would they have any idea that this was a problem? Unless you are starting to tell.
Well, because Alex has made everybody aware, and the resource officer at the school is aware as well. Because he was called by the sheriff's office.
What? Because he was called by the sheriff's office?
Yeah, he was called by the Kent County Sheriff.
Well, we'll deal with it at the time. I'm sure that the parents can indicate, look, we're just having some difficulties here right now. You haven't lost custody any different than it was before. It's just he's not there right now. So no different than if he went and spent 4 weeks with his mom, you wouldn't change custody. So, nor would you change. You need to work with him to make sure that he stays there. Go to bat for your son instead of throwing his stuff out. If it becomes a problem, you can bring a motion or something, Mr. Gordon. I don't see schools kicking kids out.
I don't think it's going to be a problem at all, Your Honor. And so I don't know what Mr. Ham thinks is going to happen, but
we'll see if
wants
it
to stay
happens.
there. That's where he's going to go. And I'm going to do everything in my power to make sure that they understand just what you said on the record. And I agree with you 100%. That's how I think it's going to be viewed. They share joint physical, joint legal custody. That's it. So he's going to stay there.
Courts schools don't usually like to get involved with this stuff, so I can't imagine they're going to be proactive on it.
Absolutely.
Good luck, everybody. I'll hopefully hear that you have succeeded in mediation and provided whatever is necessary. If not, I'll see you in the future.
Thank you, Your Honor.
Good luck. Thank you.
Thank you.
We're adjourned. Both parties are present. This is a request by the defendant mother, a ROPA motion. The parties were divorced last year, April 12. And it was done as a DO, as no child. What were you pregnant at the time, ma'am? Did you tell the court you were?
I didn't know I was pregnant until the 10th of April, and then I missed our hearing because I thought our pro-con was the 13th, but the scheduling conference was the 12th, and I thought that one got canceled, so I was planning to go to the pro-con, but then they ended up doing the pro-con at the scheduling conference. Does that
Did
make sense?
Mr. Gordon know you were pregnant?
No.
So he would have answered at the time of when he is asked, to the best of your knowledge, is Ms. Gordon pregnant? He would have said no, and rightly so, right?
Correct.
All right, but who's telling you now that you need? I assume River is not 0. How old is River?
He was born in November.
All right. So you are trying to find that River is born out of wedlock. Sir, do you have any problem with what I need to do is order a quick DNA test to confirm that River is not yours. Does anybody have a problem with that? You don't believe he's your child, do you, Mr. Gordon?
No, sir.
In heaven. If all three of you were here, if Dexter was also here, we could probably make an agreement, but based on this. All I'll do, I enter an order for a quick DNA test when it comes through. I'm assuming you're not going to be the father. At that point, you can bring it back in front of me and we'll enter an order, but I just need it in the file that he clearly is not the father. Or you don't have any relationship with River at all or anything?
No, sir.
Like I say, if all three parties were here, and is Dexter the father?
He is, and he's in this room, but does he need to be officially called in order to be a part of this?
All right. Are you married to Dexter now?
I am not.
Okay. But he is the father and he's willing to say that on the record so that he will now be responsible for the child as well as child support?
Yes, we have actually already filled out the affidavit of parentage and had it notarized so that we can send it to the state of Michigan.
Mr. Gordon, if I put everybody under oath, are you all right with just not having to go to a DNA test and just finding that River is not yours?
Yes, certainly.
Why don't you have Mr. Lammy?
Yes.
Right, you can all put your hands down. Mr. Lammy, you understand that you believe you're the biological father?
Yes, sir.
Ma'am, you have no, you are saying that he is the biological father?
Yes.
And Mr. Gordon, you don't know, but all you know is that you are not the biological father?
That's correct.
And you've had no real connection with River since birth?
Also correct.
All right. And Ms. Gordon, you are stating that you are sure that Mr. Lammy is the father, and you have indicated that you're going to, once it is determined that Mr. Gordon is not the father, you intend to file an affidavit of parentage making Mr. Lammy the father. Is that correct?
Correct.
And you agree to that also, sir, Mr. Lammy?
Yes, sir.
Okay, you understand that you will have legal rights with the child that include such legal rights as the legal right to pay child support. You understand that?
Yep. Yes, sir.
I think under the circumstances and the agreement of all the parties here that I'll enter an order instead of having to get a DNA test, since everybody agrees to what's going on, I'll enter an order that River is a child born out of wedlock. Mr. Gordon, you won't have any responsibilities. And then once that is in, I hope you need to file that AOP, that affidavit of parentage. Okay.
Yes.
We'll get that order out to you soon, that the child is born out of wedlock, and unless there's anybody who objects to anything or wants to say anything further, we're done here today. Mr. Gordon?
Thank you.
Thank you. Ms. Gordon, Mr. Lammy, anything?
Does the AOP need to be filed with Kent County at all, or just with the state of Michigan?
Generally goes to the state of Michigan.
I
For
didn't
the
know.
records, but it'll tell you right on the affidavit of parentage probably where to file it.
Yeah, we've been in contact with the state.
All right. Good luck, everybody. Thank you. Thank you for making this pretty painless. Thank you.
Yeah.
Yes, thank you. It's Hall versus Engstrom. Ms. Hall has not appeared for the court. Mr. Scazzari, the attorney, has indicated the service that was made on her. I'm not positive the date that it was sent, but I'm certain. Are you telling me you mailed it more than 14 days ago?
I did. I mailed it on February the 1st, Your Honor. Actually, that's
That's a
reflected.
lot more than 14 days ago, and you've had no response from her or anything, correct? All right, this is the father's request for custody, parenting time, and retroactive child support. Mother received sole legal custody back in 2020. She moved to Detroit. Mr. Scazzari is saying that she moved in spite of the fact that she knew she was not supposed to move more than 100 miles. And it's true, although with legal custody, it's almost a given that she'd be allowed to. However, that doesn't really come into play because apparently since moving to Detroit with their child, Mariah, who is 16, almost 16 and a half, since moving there, Mariah has left and come back. Mr. Scazzari, I'm not really sure I understand how much and where and when, because she came back and moved in with her mother's ex-boyfriend and then others. And she's been kind of back in this area for 3 years. Does she live with your client right now?
She does, Your Honor.
How long has she lived there?
I believe she's been there it's been kind of back and forth, Your Honor, but approximately 2 years, Sean, is that correct?
Yeah, the paperwork I submitted, yeah.
When you say back and forth, does she go back to her mom for a period of time or what?
I can speak to that, Your Honor. She doesn't go back to her mom's. What ended up happening, she's been in a few different places. She was with Miss Hall's ex-boyfriend, then she moved in with one of Miss Hall's friends. She finally went to Mr. Angstrom. Ms. Hall attempted to bring the minor child back to her home in Detroit. The minor child did not want to go. And for the approximately 2 years, she's lived with Mr. Angstrom. So that's just to provide history to the court of where the child has been.
I got it out of your motion, but some of it, I was concerned that when it said that she's using the father's address for school purposes, it almost sounded like she was using that address but not living there. Okay.
Certainly, she lives there, Your Honor.
All right, and has for a period of time, which certainly provides enough information for me to meet Vidvarka. There clearly is a change of circumstance if she's not living with her mother and has not done so for a substantial period of time, whether it is 6 months or 2 years. That's plenty to have an evidentiary hearing because there is a change of circumstance with her living there. She goes to school from your residence, sir?
Yes, she just left for school. I had my fiance's mother bring her just now. She
what school? Okay. All right, that's fine. I've got enough here to say there's clearly enough to have an evidentiary hearing. I'm sure Mr. Scazzari, if he has not already told you, will explain to you that I can't change custody on a Friday morning. I have to have an evidentiary hearing. It's just required. And we'll send out, I will get in touch with Mr. Scazzari as to his schedule, and we'll set up an evidentiary hearing sometime in the future for the change. Okay.
All right.
I will tell you, Mr. Scazzari, I don't buy anything about the retroactive modification. It is not appropriate. I've looked through the register of actions. There was one motion that was filed back in 2022 as a sovereign citizen, which was summarily denied. I don't have any other requests for it, but the child support will be effective when this was filed. Okay, it goes only back to that time, but as far as a request for retroactive modification, I can't retroactively modify unless very limited things have been met. And like I say, the only motion that I had, and I went through the register of actions, I got it because your paper didn't come through, does not indicate any motions for child support other than the one that was sent to me, and that was quite honestly frivolous. It was a motion filed under being a sovereign citizen. Okay.
Certainly, Your Honor. Is the court, forgive me, just for the sake of procedure, will the court be hearing my argument with regards to retroactive support at the evidentiary hearing, or is the court going to make a decision today?
You can make a short argument, all right, but I'm telling you that unless something is significantly different, I can't retroactively modify, and if it wasn't really requested, it just doesn't happen. Okay. I understand the child's been with him for maybe 2 to 3 years, and it seems like I should, but I can't retroactively modify. But we'll see I'm not going to stop you from making your argument as long as you're not, it'll be short, but we'll worry about it at that time. I can state right now that we'll have an evidentiary hearing regarding custody and parenting time. And I guess I'll let you say child support.
Thank you, Judge.
But you understand what I'm saying?
To a degree, Your Honor, respectfully disagree, but I will.
You can respectfully disagree all you want, but I don't believe that that I'm wrong. So we'll deal with it. I won't shut you out at this point.
Thank you.
All right. We'll get in touch with you for an evidentiary hearing.
Thank you.
Good luck, everybody.
Have a good day.
You too. Mr. Harris is a lot younger than I thought he was.
Oh yeah.
All right, versus Parnell. Parnell in name only because it's my understanding that Miss Parnell is deceased. This is Father Mr. Harris asking for a custody order because the mother is deceased. She apparently died in early December. Sir, I mean, I don't mind if I give you a custody order, but why do you need one? You're the father. I don't need a custody order because I'm the father of my kids.
Yes. I was under the understanding that because I when I go to file things for him and everything under his birth certificate and everything, I'm always walking around with this with her death certificate saying, okay, I don't have anybody challenging me. Because I am a single father now, a lot of people are like looking at me like, where's the mother? And I gotta let them know that she is deceased. I am in charge of him. And then also before this, before all of this, he was under the guardianship of Sheila. Now she's not over the guardianship anymore. And I was the father then, right?
Was the guardianship dismissed?
Yep.
Okay.
And the guardianship is dismissed. And now I just want to go be able to bring a court order showing that I have custody of him. So I should be able to take over everything that was done under Sheila or under what's the name over to me. Basically
I'll short circuit it. I mean, I thought there was something in here that says that you're the father. We heard that Bernal Harris is the father of, and we already issued that. I don't know why you would need anything more than that. We're just kind of, but
I'll give you an example of why I needed that was because when I went to the Secretary of State to fill out everything for him, Sheila went in with the guardianship. Now we're not against each other. I brought Sheila to the Secretary of State and she gave up Nayor willingly. But because of that, like guardianship paper, they said, well, until they get something that says she's not guardian, which I got that paper now, saying that she's not guardian. I had to, like, my father, my paperwork saying that I was father was not enough to remove any
I understand that because they have guardianship, and even though you are the father, and even, I mean, the same thing will occur even if I say you got custody. I'll issue a quick order that says that you are the father of that child, that you are the legal father of the child, then that you have full custody until further order of the court.
Yeah,
that's fine. It's just I'm kind of bothered, not to you, I'm bothered to the people on the outside who, because you are the father, they are always questioning what you can do. Okay.
Yeah.
It's having to carry a document around that says, look, I'm father. I never had that. Nobody ever questioned whether I was father. If I went to school and stuff like that, they had a mother and all that kind of stuff, but nobody questioned it. I don't know why they question you, but we'll do a quick order that will indicate that you are the legal father. We've already got one, but I'll reissue it, that you are the legal father and that you have full custody of your child.
Okay, thank you. Because
it'll be a few days till it gets there, maybe the end of next week. I don't know, but you'll get it. All right.
Okay, thank you so much.
Good luck. Take care. Thank you for letting us see your child.
Yeah, thank you. All right. Bye.
Take care. Bye. Is this the last one? Left here. Oh, okay. Yes, both parties are present. Mr. Baroka is represented by Ms. Mobilia. She is also present. This is a custody motion by the mother. Filed. It basically says the only custody order that I find, Ms. Mobilia, and maybe I'm wrong, but was the order from the original DS case, which primarily gives mother the custody. There's nothing about legal custody. There's basically gave mother physical custody. Is that the only order that, because I couldn't find another one?
But that is the only order, Your Honor. These parties have been operating without order since, I think, 2014 was when that order was issued.
Yeah. And it appears that the kids have primarily lived with the father. Is that correct?
As indicated and admitted to by Ms. Thompson, since 2020, they have lived with my client.
Okay. Yeah, I've noted here that since 2020, kids have lived with dad. Ma'am, what do you have that changes any of that or prevents me from saying that I'll continue with dad? What do you have?
The reason why they are with their dad is because of COVID.
Yeah, well, I understand, but that's 3 to 4 years ago, and they're with their dad. I'm not really that much interested in why they're there or whatever. I'm only interested in reality. They've lived with their dad for 4 years.
Yep, and we've been in good terms. And like I said, even in the first case, I don't disagree that he's a bad dad at all. My thing is that there's been certain things that lately, within these 3 months, that have been said by the kids that are really starting to bother me. And it's not something that I can communicate with Brian. I don't communicate with him at all. Mostly the communication is between me and Lexi. And if I was to dare even ask about the kids staying with me, or I want to have one of the kids, the response has always been from Lexi. It's never been from Brian.
So do you get the kids?
I've asked her because I'm concerned about.
You get the kids at all?
Yeah, I get them Friday, Saturday, and Sunday.
Okay. And then Billy, I think you said you don't have any problem with continuing that, do you?
No, I don't. They have every weekend, and I outlined it's from Friday at 5 to Sunday at 8. She has every weekend.
And I know it's not in a court order, but why don't we put that in a court order?
I'm willing to do a court order formalizing what they've done over the last 4 years, Your Honor.
Ms. Thompson?
That is my major concern, is that for me, it's starting to be the situations with Brian and the kids and how they're coming over here. And it's not like it's just one little thing that I see wrong. It's how Brian's starting to be with the boys. And it didn't start off like that. It's getting like that. So at first I was
what you're talking about as far as getting like that. You also realize the kids are 13 and 16 and they're gonna come and tell you stuff, and then they're gonna go tell dad stuff that's totally different.
This was conversated between me and Lexi, that Jandro and Brian had gotten in each other's face, or Jandro got in Brian's face. And then when I asked him, it was because Brian punched the door he punched the door with his hand and broke the door. So I had not heard of Brian being like upset or anything. But then like a couple weeks pass, and then it's like they come and vent to me in my room, and it's just venting about how they feel like they're not being treated right. They don't think that they're being treated fairly.
You don't think that that a 17-year-old, 16 and a half, and probably 13 and a half, that they don't use one parent against another?
Well, no, because me and Brian, for the most part, in all them years that they have been with Brian, I never get reports of any kind of anger issues or there's disagreements. Never. They really do respect Brian. But now it's starting to concern me when it's the little one, the 13-year-old, saying, you know, I don't feel like they ever hear me. They don't listen to me. And I see him, I go to a basketball game. He doesn't want to return back. And then Lexi says, get in the car, Marcos. And Marcos is like, no. And he's crying. And I say, okay, I'm going to take him for a drive, Lexi. I want to see what's going on. And this is not something that I'm like trying to instigate. And I said, so what's going on? And he goes on and on about how he's not being treated fair. And he's just frustrated. They don't listen to him. And not every kid gets the same treatment in that house, like how he gets treated. So then I go to drop him off. He still doesn't want to get off. And I don't think it's necessarily that it was so much Lexi. I think that it was a lot more of what they feel towards how Brian's going to react. And I don't think that it's ever been closed doors like that with them. Like, we've always kind of talked mutually, and we agree that the boys, even with Lexi, I've told her, my top priority is their mental health. That's always going to be the number one priority. They have been through a lot of stuff.
So what are you suggesting that I do here?
My thing is that I wanted to sit down and mediate with Brian, but the way his responses have been, how he acts out.
What are you asking for relief from me that I can do? What is it?
I want to be, like he says, to be a better mother. I want it to be fair because I've never been a crappy mother, an abusive mother. So I want it to be fair. Just like how he has them, I want them as well.
Just like he has them what?
How he has them Monday through, I've never said I wanted to take them from him, ever. I said that I want to be with them so that either there's some frustration going on in that household.
Every weekend.
Friday, Saturday, and Sunday.
Yeah. That's what I'm just trying to figure out what you're asking for. You want more time? I
wanted to add Thursday. That's what I wanted to do.
Why?
Because I feel like it's too much for them over there.
Ms. Mobilia, quite honestly, ma'am, if you're going to do that, that's changing an established custodial environment, because clearly he has one. You may have one too, but to modify an established custodial environment with another 52 nights, if you will, I got to have a hearing to see if that's in the best interest of the children. And what you're telling me is just, I mean, these are also teenage boys who are, I mean, I raised boys, okay? And even when I was married, they have a tendency to, oh, poor me to mom, and then, oh, poor me to dad, this kind of stuff. So, I mean, you're not giving me anything of substance at all. That there's a reason to modify the custodial environment. However, Ms. Mobilia, as you're aware, she does have custody. through the only custody order that is there.
She has, though there's been no formal determination, Your Honor, other than the judgment of support from
Right, there's clearly not a court determination, and as far as legal custody goes, I'm forced to have a hearing if somebody wants to do anything other than agree to something like joint legal custody, which would seem like it would be the smart thing to do, but I have to have that. And she has physical custody through the only order that is there. So it's almost like I'm going to be forced to have an evidentiary hearing for custody. And ma'am, you're going to have to, believe me, if you're going to try and get extra time, you're going to have to show why you're going to invade his
It's honestly his violence that is starting to show up. It's not.
Your Honor, if I can, Ms. Thompson has spin a tail here, and she hasn't put anything in her motion to the court that says that. And the only reason that this is filed, Your Honor, is because on February 9th, you awarded my client, and miraculously the same day, she filed this motion. She worked nights.
I actually had already got mediation. I wanted to actually do mediation. It wasn't necessary that I ran off to the court and that's what I did. I wanted to mediate because I do feel like my kids are frustrated over there. And I do feel like their mental health isn't being taken care of like it should be. And they, like they say, one of them has a mental disorder, which by the way, he really does not. It's just, they have ADHD and they're hyper and that's it.
All right. The reality is I can send this to mediation to begin with to see if there's anything that's going to change. All right. I do, if mediation doesn't work, I'm almost forced to have an evidentiary hearing because to get, whether it's joint legal, I mean, to protect your client almost, Ms. Mobilia, that he's asking for custody or at least joint custody and setting parenting time and all that kind of stuff. I'm almost forced to do it unless you can mediate some type of an agreement on this.
And I understand that, Your Honor. I would ask that at this time you award the parties temporary joint legal and joint physical custody pending mediation and the evidentiary hearing if necessary.
And that's what I'll do. You have a mediator in mind, ma'am? Do you know of any mediator you want to go to?
I do know of one. Yes. Over by Chicago Drive. I'd have to look at the name of the person I would want. It did even out the dates fairly. That's all I want is I feel like I need to be in their lives more. And just like Brian says, to be a better mother, that's what I want to do.
All right. Ms. Mobilia, any ideas who you think would be a mediator?
Generally, Your Honor, I use either Sean Perry or Mike Dantema. Those are the two I usually use.
Mike Dantema over on Chicago Drive?
Mike Dantema is off Knapp. The only law firm I know on Chicago Drive would be Michelle McLean's firm. So I don't know that they do mediation, but Sean Perry does it and her fees are pretty modest and she does a good job. And
Ms. Perry is somebody whose fees are less and you guys got to split the fees.
Yeah, that's fine.
So do you have a problem with sending it to, Sean Perry's well known to this court as one of the most effective mediators. Okay. She doesn't reach an agreement on everything. There's a case earlier that went to Sean Perry in these motions. Do you have a problem with sending it to Sean Perry, ma'am?
I do not.
Then why don't you put in there that parties will go to mediation with Sean Perry, the costs will be split. We'll give joint legal and physical custody to both parties on a temporary basis. And I think.
Do you want me to put in there the parenting time that's currently being exercised as well, Your Honor?
The parenting time that's currently, she gets Friday at 5 till Sunday at 8. And that's what we will do in the order. You can also put in there if you want that should mediation not be successful, the court will be contacted for an evidentiary hearing.
Okay.
If it's not successful, Ms. Thompson or Ms. Mobilia, you can contact court, say it's just, we didn't come up with any kind of agreement. Can you schedule an evidentiary hearing?
Okay.
Right. Ms. Mobilia, you made motions on, not motions in your answer, some things about improper service and whatnot. Ma'am, as long as this case is going, you will serve Ms. Mobilia also. Do you understand? If you file motions, you'll file it. You'll give Ms. Mobilia notice also.
I'll be more than happy to do that because obviously with Brian, it doesn't go well.
understand, and that's the best thing you should do anyhow. I'm not gonna sanction anybody right now. Man, Miss Mobilia, I understand. Nobody is more frustrated about the lack of following the court rules with any sort of numbered paragraphs. You just violate the court rules, man, by the way you file a motion that is a long, drawn out, just written thing. It's supposed to be done in paragraphs. However, Ms. Mobilia, the only thing I got to tell you, and I know you know this, very few in pro pers do it in numbered paragraphs. And if I had to send everyone back for improper following of the court rules, I'd be sending so many back, it wouldn't be worth it.
I understand, Your Honor. Just the court has to understand that filing a response to basically a run-on paragraph that's a full page is makes the process more tedious and expensive for my client.
Look at that. I practiced 35 years and I've done this for a lot of years. I'm just not gonna. I mean, I know it's very hard. So that's all taken care of.
All right, Your Honor. So in terms of my attorney's fees, are you denying them or reserving them?
Oh, let's see. I don't know why I would reserve them based on the number, based on what you ask for. You can always come back, and if other things go wrong, you can always ask for attorney's fee. I'll deny them at this point.
Okay, thank you. I'll prepare the order, Your Honor.
All right. Well, hopefully not see you guys back on this, but if I do, I do. Good luck.
Judge, so when do I find out about mediation? Or how do I find out?
Usually, Your Honor, I send an email and I will include Ms. Thompson in the email to Ms. Perry's secretary, who will give us dates that we can see who can show up at those times.
Fine, and if you want to contact Sean Perry's office and tell him we got to go to mediation, you can contact them too, man. Is her name SHAWN?
SAHAW, yes.
Yeah. Sean Perry, Perry. You can look her up and contact her too. That's what, but it'll be in an order that you're going to see that she's going to be mediating. Okay.
Okay.
We'll get to it. All right. Thank you very much, everyone. Take care. Have a good weekend. Thank you.
Thank you. Bye.
Mason versus Rosales. Both parties are present together with their respective attorneys. Ms. Bransdorf for Ms. Mason, if I'm pronouncing that correct, and Ms. Johnson for Mr. Rosales. This was a motion made by the father regarding custody and parenting time. The parties have apparently been separated since April of 23. They've been kind of exercising 50-50 parenting time. The UCSO shows 50-50. And there's a judgment of initial custody, which gives custody to mother without prejudice to anybody filing, so that they don't have to do Vadvarka and stuff like this. And I'm probably at the point where I'm going to have to do that. Ms. Johnson, I know I gather, well, I've also read your motion and I've read the mother's response. There's some disagreements in this. Ms. Johnson, what would you like to say?
Ms. Bransdorfer and I have been talking, and I believe the parties have an agreement that at least will get us through this motion. I think there's some details of the parenting time schedule that probably need to be worked out. But I can
tell you, but you should have interrupted me right at the beginning and told me this, and I wouldn't have gone through any of it. I'm just kidding. That's all right. I'll get out of your way and let you tell me what it is.
Okay. The agreement is, and Ms. Bransdorfer, of course, you can correct me if I have any of this incorrect, is that the parties will agree to the parenting time schedule that was stated in plaintiff's response, paragraph 12, which is the schedule that we agree has been happening.
Yep.
Regarding phone calls, that the party who does not have parenting time may have phone contact with the children in the mornings and evenings, limited to 15 minutes per call and not to interfere with bedtime routines. But we're specifically going to say that we have to have the call at least 30 minutes before bedtime.
Okay.
We have agreed upon language regarding the prohibition on disparaging comments. I can read that into the record if you want, but we do have that in an email.
I assume I assume it's kind of what was requested in paragraph 3 from Ms. Bransdorf.
Yes, it's basically exactly that, I believe.
All right.
We do have a provision about communication, that the parties shall not insult, demean, or harass the other party. Neither party will interfere with communication between the other parent and school personnel, healthcare providers, counselors, coaches, etc. The parties are also going to agree to start using Our Family Wizard for all written communications, and that they will add any scheduled appointments for the children into Our Family Wizard within 24 hours of scheduling.
Okay.
regarding the counselor for the oldest child, that the parties agree that the mother will select the counselor and notify the father of the counselor's name and contact information, and that it will be a female counselor.
Okay.
And this morning, there's been some more discussions back and forth a little bit, and we're specifically regarding the legal custody piece. Of course, if there's no agreement, we'd of course have to have a hearing on that issue. But I think we're making progress on that piece. And there are, of course, some holiday parenting time details that the parties still need to work out. But I guess I'll defer to Ms. Brandsdorfer on the legal custody piece if we have an agreement.
It would only, I would assume that if it was an agreement, it would only be a temporary, I mean, all of this is a temporary order, right?
Yes.
Yes.
Ms. Brandsdorfer, you're not
Thank
going to
you.
tell me you're going to cause problems, are you?
No, I am not. I am not. And I'm not throwing anybody under the bus.
All right.
Because Ms. Masson and I are here together, I do not have the same kind of access to my computer that I normally would because I am tech incompetent or at least challenged.
Well, join the club.
So I was not able to send to Ms. Johnson the language I propose to kind of describe how joint legal custody works, so the parties know what decisions they need to talk to each other about, what decisions they're empowered to make while the children are with them, those kinds of things. I believe—
Ms. Johnson, those are pretty standard. You're not really changing what I see in all kinds of judgments defining legal custody, is it?
Well, she hasn't seen it yet, unfortunately, but I will get that to her. I don't think there's anything unusual in it. But, you know, what I'm used to and what other people are used to is maybe not always the same. If that is the case, then we do have an agreement on joint legal custody. If it's not, maybe we don't. Ms. Johnson and I agreed to ask you about a friend of the court referral if we need one, recognizing that you don't usually do that. But
right.
So I think maybe we could hopefully cross our fingers, presume this is resolved, and come back specifically and ask for a case conference with Your Honor if it's not.
Ms. Johnson, how does that sound to you? It sounds pretty good to me, because since the two of you are now on this, I have a great deal of hope that it is going to get resolved, okay? And if there is any problem, you could call my clerk anytime and I'll get you in on a case conference, unless it's something that I got to, unless I got to do a lot of electronic stuff, and then I don't know what to do. But quite frankly, I'd be more than happy if you got a small thing that you want my advice on. I'd be happy to tell you where I'm going with it. But as far as legal, I can't imagine that you won't have a agreement on it. I mean, I see attorneys all the time send through joint legal custody, and then they list A through M as what that entails. And I'm assuming that's kind of what you're saying, Ms. Brandsdorfer, and you, Ms. Johnson, also has an understanding of what joint legal means.
Yeah, it's only through J though, so I feel pretty good about that.
Okay, well, you've been really brief then. But if you have a problem on that, give me a call and I'll be glad to be on Zoom here for 15 minutes, and you can get in very short period of time unless I'm out of town.
Okay.
Is there anything else that we need to address then? You still want referral to the friend of the court? You're talking to the wrong guy, but if you still want, do you think you need a referral or
Yeah, I'm hoping that we don't need a referral. That's why I was suggesting, if we think we do later, better to talk to you just for a few minutes and find out if we can convince you than to have a whole nother motion.
All right. Yeah, you guys can call and try and persuade me why to send it to the friend of the court so that it'll delay it for a couple months before I have my evidentiary hearing, because almost always end up in that anyhow, but I'll be glad to. I mean, as long as you guys are being this reasonable, I'll bring you in and talk to you anytime you need it. All right.
Okay.
Thank
Anything else? Yeah, I won't refer to the friend of the court at this point. I hope we don't need to. Hope that this continues to move along in a manner that is appropriate. Thank you for your assistance, everyone, because you all have to come together to do this, and I appreciate it. I really do. It's been a long morning.
Mr. Nice do you do the order, or do you want me to do that?
I can draft the order, and if we reach an agreement on the legal custody determination, maybe we can include that, but I can definitely draft the order.
All right, thank you.
You can draft the order, and Ms. Brandsdorf will get you the legal stuff before you draft it all and send it in, as opposed to sending in two. All right. And if you don't really agree to that kind of stuff, call my clerk and let me see what we're doing. All right.
Right. Thank you.
Good luck, everybody. Thank you. Thank you for working together. That means both parties as well as the attorneys. Have a great weekend. Thank you.
Thank you.
Thank you.
That's it's the stuff where I start out talking all this stuff and then they sit there politely and then say, we don't really need that. Yeah, if they're Venta versus Pagada. Wait a minute here now. I've got the defendant, the father has made a motion for parenting time, says he simply wants more parenting time. Right now, I believe he gets a couple hours on Saturday at the mother's home.
That's correct.
And sir, you simply say, and that was from October 23 of 23, that you have 10 a.m. till noon on Saturdays at her mother's home.
Yes, that's
you're saying that at some point you think you're going to get a 2-bedroom apartment and stuff like that. You have that?
No, right now I'm renting one room, just a room from at a house off of. I'm looking into a 2-bedroom apartment. Just going through applications right now. But
have you visited all the time on Saturdays?
I just recently moved back to Michigan from Texas the last few weeks. So I was working out of state for a couple of weeks, but
so you really haven't even seen the child hardly at all.
Yeah, I have seen him. I've been talking to him on the phone every day.
Well, that's not seeing him. I'm saying you haven't had any.
I was working out of state for the last few months.
So the October order, how many times have you seen that child since the October 23 order?
4 times, 4 weekends, about 4 weekends, 4 to 5 weekends.
That wasn't what was expected. I'm trying to get you to have a relationship with your son so that he feels good about being around you and stuff.
Yeah, I would just simply like to increase the time. I'll be staying in Michigan for the duration of my life, I'm assuming. So I just wanted to increase the parenting time to a few more hours. So we're on the same page as far as I want more of a relationship. I'm living in Michigan now. I'm staying in a 1-bedroom, or I'm renting a room right now, looking for a 1 to 2-bedroom.
How old is this child, ma'am?
He's 7 years old.
Pardon me?
Our son is 7.
All right. And I mean, quite frankly, sir, I mean, I know you were out of his life from 2018 to 2023, apparently. I'd say it's no fault of your own, but it is. You found yourself in prison and then you got out and now you started to try and reestablish. I'm happy to reestablish your contact with your son. It's got to be done in what I consider a break-in type way where you got to build something. Your son doesn't really know you. He was 22 months when you went away to prison. Okay. And we're going to get it so we can try and get you to something more reasonable, as long as you are doing what you're supposed to. No talk of the end of the world and stuff like that to him.
Okay. No, I just recently got a vehicle as well, so I'm in the process of just getting back on my feet. And I appreciate it. I'm not working currently because I moved back from Texas. That's where I was working, and I didn't want to be so distant. So that's why I came back. I've been looking. I've been applying. I should start working sometime this week. But yeah, I just got a vehicle about last week. So.
All right, ma'am, what's your thought? I mean, I'm telling you right now, he has to establish his presence in his son's life. His son is 7, and he has to establish it, and then we work up into him having more time. It's just he's the father, and unless he goes back to prison or moves to Texas, he's going to get to see his child. Okay. So what are your thoughts? He is still visiting now with your mother?
Correct. He's still going. Again, our son is not comfortable with staying with him still. He doesn't feel comfortable. He doesn't, like you said, he doesn't know him and hasn't established that yet. Also, I have put him into new sports. I want to say December. He's in gymnastics, basketball, taekwondo. I want to make sure that he will also help me. This isn't about money or anything like that, but he's been ordered child support and he's made 2 payments since he's gotten out of prison. I just want to make sure he can support our son.
We'll work on all of that. It's going to take some time because he was in prison and things just take some time. I mean, I understand he can't jump out and get a job as president of General Motors right out of prison, and he's working and he will, and he's going to have to pay his child support or else they're going to get a warrant for his arrest and pick him up. And I'm assuming, sir, you're going to work on that, right?
Yes, sir. Yeah. I've been in contact with the FOC. I filled out probably 43 applications in the last week and a half.
All right. I'm not expecting perfection from you, okay? But I am expecting that you're going to visit your son for a few hours. Ma'am, I don't know where your house is, sir. I don't know if it's appropriate when you just got a room somewhere.
Okay. I wouldn't mind if I could just increase the hours on Saturday and Sunday and to Sunday at her mother's. If I can get at least 3, 4, 5 hours more.
Well, here's also going to be the difficulty is that her mother is kind of inconvenienced. You understand that?
Yeah, I understand.
The mother will do. Ma'am, what if I gave him instead of 2 hours, 4 hours on Saturdays? I gotta somehow get your son so he becomes used to father. Okay?
Of course, and I've also told him, and my mother has told him too, that he's more than welcome to call my son and stop and visit her at her house after school. So I don't know why he hasn't done that.
I didn't know I could do that. I didn't know I could do that.
I have text messages, but okay, don't interrupt me.
I'm sorry.
But yes, that'd be fine with 4 hours.
All right, I'm just going to change it from 10 a.m. to noon till 10 a.m. to 2 p.m. on every Saturday. For a period of time, sir, I'm going to tell you that if you skip some of these, it's going to put you back, okay? You're not going to get the increase. The reason that I do it every weekend is so that you can not wait 2 weeks or something to see your son. It doesn't do any good. Well, what kind of time? I mean, if he's going to get a job, so he's going to be difficult to figure out exactly when he can be there, probably be there on Saturday. Sir, if you find that your job that you're going to get interferes or something like that, you can talk to grandmother or mom and see if you can change when and where, but if they don't agree to it, you're going to have to come back to court.
No, that's fine. I didn't even, yeah, that's fine.
Ma'am, should you tell him at this point to stop over after school, to see him for an hour or two on Wednesday?
Yeah, he can go ahead and call my mom. And I mean, as long as she has no plans, should be no problem.
Thank you.
That's about as good as you're going to get. And I don't understand that the mother and the grandmother are being awful kind. So do not.
Nope, that's fine.
Screw that up. I'll put in the order that you get 10 till 2 on Saturdays.
Okay.
And any other time you can agree upon between the parties. Okay.
Okay. Thank you so much.
Thank you, sir.
Ma'am, thank you. You're doing the right thing, and sir, you're doing the right thing in the way you're going about it. Just get so your son feels comfortable, and
of course
we can start to increase your parenting time. But it's not going to increase in a month. You're going to have to work at it.
That's
right? Good luck, everybody. Thank you.
Thank you.
Thank you, Selena.
Well, she's really nice and giving. I mean, the grandma's really nice. I mean, we're waiting for him, and I'm sorry you had a long wait this morning. I've been working all morning. Somebody's got to be like last, okay? And it's nothing to do with you. It's not. I apologize, but what can I say?
Yeah, thank you. I understand it's not under really your control, so it's fine.
There isn't a lot under my control. I get handed files and do the best I can after this. And if it's any consolation, once you're done here, I'm done for the morning. Now all I gotta do is get see, normally if Mr. Teasdale was taking time to log on like this, I'd put you both on mute and have you sit there while I take another case, but I don't have any more cases to take. So we'll just wait for him to see if we can log in.
Well, thank you for waiting.
Oh, believe me, I want to get this done. Do you have his number or anything?
I do.
Maybe you could call him or something. I don't know.
Or if she doesn't want to, right?
Or if you don't, yeah, or if you don't want to, my clerk can call. I don't know if
Can I just give you his number?
yeah.